my lord.
What do you want?
For listing, my lord.
Why?
Well, it was last listed on 5/3. That's when that after 4 it will be listed. Then it has not been listed till date.
What is that CRP for?
CRP for that it is for a succession case. At argument stage, the respondent filed a petition. They want to reduce additional affidavit. That was
CRP IO.
yes, sir. IO
Okay. When is the
29.
when is the
Well, let's not tell.
24?
Sir, please, Your Lordship, I would like to mention item 45, my lord. From the office note dated 16/3, we have learned that respondent number 9 has expired.
What happened?
The respondent number 9 has expired. From the office note dated 16/3/24. We need to read.
We'll see when the matter reaches.
Please, Your Lordship. Lordship, for item number 48, Your Lordship, we have filed for our dusty affidavit on 20th, Lordship. That's it.
For listing of a MAT appeal, my lord, arising out of a order passed by the district judge.
MAT appeal, I think, is before another bench, or this court is
Not,
taking up. This court is not
Lordship is
taking up
senior
those
bench, my lord.
appeals.
Lordship is senior bench.
Huh?
Honorable Justice,
No, no, no.
Thakuria is
There is
also
another bench.
there. Mitali Thakuria is also there.
We have to mention there because I'm not taking up MAT appeal.
Yes. Yeah, like.
But I bring for listing on IA in connection with an MSc appeal.
Go there. MSc appeal is not before me.
MSc appeal is proposed.
No. I don't have MSc appeal is mine.
Yes.
Go there. Mention it out there in court number 22.
Your Lordship, for item number 39, we have filed affidavit regarding the report. That may be for
Please, Lordship. In item 33, we have filed on application for early hearing of the main FT. It may be got on record.
IA for bringing IA on record. Not possible.
No. We have filed a IA for early hearing of the main appeal. That IA may be brought on record. Item 33.
What is the number of the IA?
1167 of public 2020.
Item number?
33.
What is the urgency?
Your Honor, the applicants are not doing well medically, Your Honor.
So what? These are 2023 RA. We'll adjourn this and fix it some other day along with I. Mr. So-and-so, the learned counsel appearing on behalf of the respondent submits that an interlocutory application has been filed, which is registered as IA number
1167 of 2024.
2024. So let this matter be listed again on 26th of April 2024, along with the state interlocutory.
Obliged.
But it yes, transfer from where to where?
Dibrugarh to my lord, Kamrup Metro, my lord.
Huh?
Family code. From FTC Dibrugarh to Kamrup Metro, my lord.
Why?
Family code. Let's see, the petitioner newly joined my lord service in secretariat. Number 1, number 2, my lord, her daughter in reading class 7 at Tonbokso, my lord, Tanbazar. Number 3, my lord, one maintenance petition is pending.
What are you? I mean, say you are the.
Petition.
What do you do?
Sectional assistant, my lord. Computer operator.
Huh?
Secretariat, my lord. Computer operator, my lord.
Where?
At secretariat, my lord.
Secretariat.
Yes, my lord.
So what's your problem?
I'll travel Guwahati to my lord Dibrugarh.
You don't need to appear every day.
No, my lord. This next day is fixed for my lord filing evidence on affidavit, my lord.
So go. He said it's your affidavit. You are the respondent.
No, I am the petitioner, my lord.
You filed the application out there.
Yes.
Now you want it here because you have been transferred here.
Number one, transfer. Number two, my lord, one maintenance petition is.
Forget about that. You filed the application there. And then you have come out here.
Yes, my
You have been transferred here. Tomorrow you will be transferred to Golaghat. Again, you want to get it transferred there.
my lord, along with me, my minor silo is.
So what?
My lord.
It's in MSC. It is in not in a family court. You need not appear on every day.
Filing, my lord.
No, nothing to. You filed your application out there. You knew it. It can't be at your yeah. He's in Sipsagar, and then you want it today out here in Dibrugarh. You were a resident of Dibrugarh. Then
My
it
mother.
can't be. You every time you shift out here, it can't be.
No, my lord, my permanent residence was in Dibrugarh, my lord.
Then go there.
Three days.
No, this is not a case for transfer. The husband comes, it's a different thing. This is not a case, and that too at that stage of evidence. Oh, don't need to. You take leave of the whatever may. You have been transferred when?
No, I will join here in Guwahati, my lord.
On 25th of May,
Yes, my lord.
2023.
23.
Almost 1 year has passed. So, another few dates only, 3-4 dates remains. Why this should be transferred here? What do you want? Withdraw or dismissal?
No, this is a permanent post, my lord. Secretariat, my lord.
So what?
For transfer.
Dismissal? Fellow, dismiss. This is an application under section 24 of the Code of Civil Procedure 1908 for transfer of title suit D number 82/2023 from the court of the additional district judge, learned additional district judge FTC Dibrugarh to the family court, to the principal judge, family court, Kamrup Metro at Guwahati. From the materials on record, it reveals that the petitioner had filed the said application seeking divorce, which have been registered and numbered as title suit D number 82/2023. It is on account of the transfer of the petitioner from Dibrugarh, transfer to her post at Guwahati. The petitioner now have sought for transfer of the said divorce proceedings from the court of the additional district judge FTC Dibrugarh to the principal judge family court Kamrup Metro at Guwahati. This court have also inquired what is the as regards the stage of the proceedings before the learned additional district judge FTC Dibrugarh, and it has been informed that it is at the stage of evidence, taking into account that the petitioner is a permanent resident of Dibrugarh, as it appears from the perusal of the application, and the said application was seeking divorce was filed by the petitioner at Dibrugarh. This court is not inclined to exercise the jurisdiction under section 24 of the Code of Civil Procedure 1908 for transfer of the said proceedings to the principal judge, to the court of the principal judge, family court, Kamrup Metro at Guwahati. Consequently, the instant petition stands dismissed. Yes, what is this?
Lordship, it is an application, Lordship, under
Yes, what have you challenged?
I have challenged, Lordship, the order passed by the civil judge. The order dated 29/1/24 passed by the learned civil judge in the division Golpara, Assam, in mixed education case number 1, in title execution number 3 of.
Why?
Lordship, may I kindly tell you, Lordship, the
You are only challenging the review order,
Lord-
not the main order.
Lordship, I have
Review has been allowed or dismissed.
review has been Lordship in favor of the respondent, sir.
It has been reviewed.
Lordship is review, sir.
Okay. So now you are challenging this.
Lordship.
Okay. What is the review? What is your case?
My case is Lordship, the lane with the irrigation department is an operation lot. Is not a part and parcel of the plan. Not the part and parcel of the.
What is the decree passed?
Lordship, may kindly see the schedule, page 23, Lordship. Schedule of the
Wait.
23.
Who
Lordship.
filed the suit?
Pan-
Who filed the suit?
Good filed by Lordship on Kanti Majumdar and other.
Okay. And what is the decree? In the result, the suit is decreed. Accordingly, it is declared that plaintiff has right title and interest over the suit land, and hence the plaintiff is entitled to recovery of past debt by evicting the defendant so and so from the suit land, demolishing and removing and further permanently restrained from disposal. Now, then,
Lordship, may kindly see page 23, the schedule of the suit plan, Lord. Our position is tag number, Lordship, 785. A plot of land measuring 1 biga, 3 quarters, 2 lessons covered by patta number.
where is the decree?
Lordship. Decree is Lordship,
Yeah, 784,
Lordship,
page 47.
Lord.
Then,
Then Lordship, our land is Lordship 785. Lord.
Then?
This is not a part and parcel of the suit plan.
did you raise that issue out there before the trial court?
Lordship, this is the fault they have
Then?
done, Lord.
How can you raise this? You can't raise all these things issue now. Anyways, the executing court can very well do it under 47.
The executing has court has Lordship initially passed the order.
Hmm.
And Lordship, they have filed their written objection. Lordship, may kindly see page 61, Lordship.
Let's see what is the impugn order.
Impugn order is page 70. Okay. So kindly see the initial order, Lordship, page 62, Lord, and 8, Lord.
And let us see your 47 application.
Page 62, Lord. Page 62, Lord.
62 is the order.
Lord.
Where is the 47
Hey, Lord.
application?
before Lord.
You never raised this issue in the trial court. Then how can you raise this issue now on the identification of the land?
Lordship, the whole case, the NP does not come with clean hands.
What clean hands?
Lordship,
Clean hands is when you are appearing on this side and the irrigation department, then we'll say clean hands. No. It was categorically mentioned out there in the plain that this is the boundary of 1 bigha 3 kathas. Then it is to be executed as per section 47. The court has the power to do it.
Lordship, correct otherwise, Lordship, but things is that, Lordship, the tag number 785 was never there, Lordship, in the starting part of the plan. It's my case, Lord.
Very well. You were supposed to raise that issue there.
Correct, Lord.
You never raised that issue. If you have not raised the issue, how can they? Why should this court interfere?
They keep some liberty, Lordship, so that
For what liberty?
they can file and review their Lord. Or in the initial title suit, Lord.
Hmm?
For filing, review in the title suit, Lord. Otherwise, there is no option. Left. There is fall on the part of the.
There is no
department.
review business of the. Why? You have a liberty to do whatever you like. Do whatever you like. This can't be like this, no? So what should I do? Dismiss with cost?
If I would like to withdraw this petition, Lord, so
Huh?
you give some liberty to us.
What liberty? There's no liberty business out there. Liberty is, you are always at liberty. State of Assam is always at liberty.
Because, Lord, that is fault on the part of the department. Absolutely, Lord, correct.
Hmm?
There is some lacunas in the. They have not raised the issue there. Lord.
You have filed your written statement.
Just 10 thereafter, they have not appeared, Lord.
That is your lookout. Did you raise that issue there? No. Hello. Dismiss.
I'd like to withdraw. Lord.
The instant application under Article 227 of the Constitution is directed against the order dated 29/1/2024, passed in mis-execution number 1/2023, arising out of title execution number 3/2019, whereby the Court of the Learned Civil Judge Senior Division Gwalpara had reviewed its earlier order dated 14/9/2022, passed in mis-execution number 1/2021. The Learned Counsel, appearing on behalf of the State of Assam, Mr. N.N. Upadhyay, submits that he would not further press the instant petition in view of the law laid down by the Supreme Court in the case of Pratibha Singh and another versus Santi Devi Prasad and another, reported in 2003 2 SCC 330, and more particularly in view of the paragraph number 17 in the said judgment. So, taking into account the above, the instant petition therefore stands closed on withdrawal. This is enough indication what is to be done.
No.
Yes. Read that paragraph, it may help you.
Right.
At number 49,
Here the suit was dismissed. Not. My suit was dismissed. Not.
Suit was
For
dismissed.
non-prosecution not, on one day,
Then
and subsequently filed a petition under Order 9 Rule 4.
Hmm.
That was
that was
also dismissed. My ground was like this, that
show me the order of dismissal of the suit.
suit lordship. Lordship may come to page 44.
Hmm.
Seven 322 is given.
Then when did you file your application?
There was some delay, lordship, but delay was condoned.
How much delay?
That was condoned, lordship. I have annexed that order also at page 52. Lordship.
Then
Then subsequently the meat case lordship which was filed for restoring the suit lordship, that was dismissed. That is a page
is
50.
this not a petition under order 9 rule 4?
Yeah.
A suit having been dismissed for default in a hearing state when the other side is appearing, wouldn't that be a petition under order 9 rule 8? Yes. Order 9 rule 8.
This order.
Then your petition has to be under order 9 rule 9. Isn't it? If it is an application under order 9 rule 9, an appeal lies under order 41 rule.
Rule R.
Huh?
Order 40.
Rule 1C. Then how are you moving 115? Isn't it?
But here lordship it was filed under Order 9 Rule 4.
Understood. You may file in whatever provision, that is your lookout. But the provision should have been actually under order 9 rule 9. And if it is an application under Order 9, Rule 9, the only consequence is to file an appeal under Order 9, Order 43, Rule 1C. Isn't it? And what is the value of the suit?
7 lakh.
Huh?
7 lakh.
So 7 lakhs, it will go to the district judge, appeal. I can convert also.
Okay, typically liberty notified.
I'll make it clear. Better off. Huh? This is an application under section 115 of the Code of Civil Procedure 1908, for short the code, challenging the order dated 5/1/2023. 5/1. Oh, no, 12/12. 12/12, no?
Yes.
12/12/2023. In Ms. J case number 7/2023. From a perusal of the materials on record, it reveals that the order dated 12/12/2023, passed in Ms. J case number 7/2023, is an order passed in an application for restoration of the suit which was dismissed for default, while an order dated 7/3/2022 in title suit number 29/2019. This court have duly perused the order dated 7/3/2022, wherein it is seen that the suit was dismissed at the stage of hearing, when the application, when the suit was fixed for hearing, was at the stage of hearing. Wherein the plaintiff failed to appear, whereas the defendants have appeared. Accordingly, the said order would come within the ambit of Order 9, Rule 8 of the Code of Civil Procedure 1908, Code Pulikud. Consequently, the application which ought to have been filed should have been an application under Order 9, Rule 9 of the Code. However, inadvertently, the application was filed under Order 9, Rule 4. Be that as it may, it is well settled principle of law that wrong quoting of a section is not material for deciding the said application. Accordingly, the said application which was filed under Order 9, Rule 4 has to be construed to be an application under Order 9, Rule 9. The consequential effect of dismissal of the said application under Order 9, Rule 9 is that order which is appealable under Section 104 of the Code, 104 rated Order 43, Rule 1C of the Code, taking into account that the said order being appealable, and that too before the court of the learned district judge at Dorong, the instant proceedings under Section 115 of the Code cannot be entertained. Accordingly, the instant petition therefore stands dismissed. Be that as it may, the dismissal of the instant application shall not preclude the petitioner herein to prefer an appeal in terms with Order 9, or in terms with Section 104 read with Order 43, Rule 1C of the Code against the order dated 12/12/2023, passed in Ms. J case number
7/2023.
7/2023.
All right.
You have a good case, but the problem is that because the court should not have, it was fixed for cross-examination, the court should not have dismissed.
Yes.
The court should have, on the other hand, said that, okay, the next stage, it should have been closed. Can't help it. Yes, Mr. Dhar,
Right.
you are back from Delhi.
I had to come
What is
on
this case?
Look, this revision application, your lordship could find my lord, or is directed against some status order, although it was passed in favor of the revision petitioner's plaintiff, your lord. Only thing, my lord, your lordship will be, my lord, if your lordship stands to take.
What are you challenging? Let us see. It's a judgment.
My lord, that these are all these orders, we prayed for a temporary injunction, my lord, we are
Ah.
the plaintiff. An order came, your lordship.
Is the suit alive?
Huh?
Is the suit alive?
Yes.
Then
Declaration of method, suit was filed for declaration of title and confirmation of possession and along with the consequential release of injunction.
Ah.
Now there was an application for temporary injunction and learned trial court, your lordship, would find my lord, pass the order at page 41, your lord. Now we did not go through all this, my lord, your lordship will come to my lord.
wait.
my lord,
Page 41.
Page 44, my
Page 41 is the trial court's order.
trial court order and my lord operative portion, your lordship will find at page 44. It is a non-specific, my lord, order suffers from ambiguity and my lord now it is resulting into chaos. My lord, no determination was there, my lord, what is the individual process. Hence I order both the parties to maintain status quo as regards their individual position over the suit land.
So there was a status quo order.
Status quo order,
Then what happened?
now my lord, there was an appeal, your lord.
Okay.
Appellate, my lord, court, it almost remains the same, your lordship, would
Okay.
see page 48, your lord. Page 48, my lord. Now, whether the suit is a public path or a private path is to be decided after trial of the main suit. That is also wrong, your lord. Our claim is that it is our patha land. Defendants say it is a path. Path means property. Property is not cow hard. Like a cow hard is not the penalty. It is their claim. Now, the suit is a public path or private path. Our claim is not path. Our state says it is a patha land. You should not disturb our possession. That is the case of the petitioner's claim. At this stage, it will be proper to direct both the parties to maintain status quo with regard to possession and enjoyment and nature and feature of the suit and till disposal. Now, whose possession, my lord, individual possession or joint possession, nothing has been determined.
Who is the
yet.
plaintiff?
We are
Plaintiff
the
is,
plaintiff.
Huh?
We are the
you are Sri Kanti Bhushan
and it
Dev.
appears that these orders were passed in our favor. Now, Lord, defendant,
You
my lord,
filed an appeal.
appeal.
You are aggrieved by the status quo order.
Status quo are non-specific. It might have been explained specific. So, my lord, I am only pressing your lordship may stand to my lord, page 19, your lord, our prayer. My lord, I'm sorry, your lordship, so far as revision petition is concerned, my lord, we are trying to obtain an order from this court, my lord. In which way, my lord, your lordship may turn to page 11C, your lord.
No, show me your injunction application.
Injunction act.
Where is it?
It is annexed to your lord. Annexed to your lordship will find that page annexer 1 is the plain, and then my lord, annexer 2. My lord, this is the 821. Annexer 2, that is
So
the
you were asking, with or without issuing notice, restraining the principal defendants from creating any disturbance in using and possessing the suit land by the plaintiff and the performer defendant and restraining the principal defendants from changing the nature and character, nature and feature of the suit land. Who is in possession?
My lord, document says, my lord, we are the Pattada. Devamanti says we are in possession. Actually, we are also in possession, my lord.
Then how can they change the nature and character?
But they say, my lord, it is a Gopat, and they tried, my lord, to disturb our possession. Now, a trust order was passed, my. And I think that there is a chaos because this defendant side did not, my lord, oblige to that order. So, my lord, I am told, my lord, that in the meantime, my lord, they have treated a Gopat. Actually, during the pendency of the division petition, it's not a full period.
Who made? Gobat. Government.
Gopat means my go means cow, my lord.
No, that I know.
Part means
But that, Mr. Dor, that is a basic thing.
Go,
I
my
know
lord,
that.
But I am trying, my lord.
But who made that it Gobat? I think the government.
Huh?
Government made it.
Defendant side, lord. Defendant.
How can the defendant is government?
No, lord.
Yeah.
Private person.
So how can they make it a
They
Gobat?
are making, my lord. They are not, because this is, my lord, nothing has been, my lord, specified or explained in the status order. So they say there is nothing in the status order. It is a Gopat and you use that as a Gopat. Why you should not? And this is the problem here. Here, my lord, actually, I am not taking for my lord. I have come with a problem here. That is the thing. So, my lord, your lordship may kindly see paragraph C of my prayer, page 11, Vibhuti Samagam. And I am, my lord, on this regard, I am, my lord, deciding, my lord, I am relying on a decision of the Madras High Court. If your lord like to see that judge. So, my lord,
No case.
I am relying.
Madras is for Madras.
So my
We will-
submission is that
Let
my lord,
us stick to
actually
Guwahati.
explain what-
Mr. Dhar, let us stick to Guwahati. We do one thing. I am not interfering with this order. Let the trial court decide as early as possible. It's a 2012 suit. It needs to have been finished. 12 years have gone
Yes.
by. Has it been finished? Is the suit pending?
Yes, my lord. Pending.
So the suit
They- they have
requires
been-
to
they are
be
delaying, my lord.
disposed of as early
Yes, my lord. Your lordship-
within period of 6 months if possible. I think that is the best way.
Recently, your lordship has passed a similar order recently.
Similar order.
By giving specified time, 7 months time, my lord. They-
Lehok. Heard Mr. N. Dhar Lennox counsel appearing on behalf of the petitioner, Mr.
MJ Kadir.
And so appear on behalf of the respondents. This is an application under Article 227 of the Constitution challenging the order dated 22/5/2014 passed by the learned civil judge Karimganj in Miss Appeal number 15/2013. Full stop. 13, whereby the learned First Appellate Court directed both the parties to maintain status quo with regard to possession and enjoyment and nature and feature of the suit land till the disposal of the main suit. Full stop. The facts leading to the filing of the instant proceedings, briefly stated, would be that the plaintiff, the petitioners herein as plaintiffs, had instituted a suit being title suit number
289.
289/2012.
12.
Seeking inter alia a declaration of their right, title, and interest along with the performer defendant numbers 5 to 8 over the suit land through inheritance, semicolon. For confirmation of possession of the plaintiffs and the performer response defendant numbers 5 to 8 over the suit land. And for permanent injunction restraining the principal defendants from creating disturbance in using and possessing the suit land by the plaintiff and the performer, defendant numbers 5 to 8, and restraining the principal defendants from changing the existing nature and feature of the suit land. Along with the said suit, an injunction application was filed seeking inter alia for a temporary injunction restraining the principal defendants from creating disturbance in using and possessing the suit land by the plaintiff and the performer defendant numbers 5 to 8 and restraining the principal defendants from changing the existing nature and feature of the suit land till the disposal of the main suit. The said injunction application was registered and numbered as case number 202/2012. To the said suit, the respondents herein as defendants have filed a written statement and contended inter alia that the land
Page 32, my.
is a public/village path
Property.
which was earlier a go park in existence in the locality since immemorial. The entire case of the plaintiff was denied by the defendants in the said suit. To the same effect, a written objection was also filed to the injunction application. The learned trial court, next, the learned trial court by an order dated 6/3/2013 disposed of the said injunction application being this case number 202/2012, holding in thereby directing that the status quo be maintained
Page 44.
as regards the individual possession over the suit land as on the date of the said order till the final disposal of the main suit. The plaintiff being aggrieved preferred an appeal against the said order dated 6/3/2013 passed by the learned trial court, which was registered and numbered as Miss Appeal number 15/2013. The learned first appellate court, that is the court of the civil judge Karimganj, by an order dated 22/5/2014, disposed of the said appeal, directing both the parties to maintain status quo with regard to possession and enjoyment and the nature and feature of the suit land till the disposal of the main suit. Being aggrieved, the present application has been filed under Article 2 to 7 of the Constitution. I've heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the submissions so made. From the submissions so made by the learned counsel appearing on behalf of the petitioner, it appears that the petitioner herein seeks for an order directing the learned trial court to decide as to which of the parties are in possession of the suit land based upon the respective pleadings and the documents filed, and to pass appropriate orders. This court have duly taken note of that the said suit has been pending for for more than a decade. And it has been brought to the attention of this court, whether it is stayed.
No stay, wait. No stay.
What is the state?
evidence, as per information from the evidence.
And it is at the stage of the cross of the plaintiff side. A cross-examination of the plaintiff's evidence. The relief which have been sought for by way of the instant application, in the opinion of this court, can only be granted at the final relief in the suit. This court, having taken note of that the suit is at the advanced stage, is not inclined to interfere with the orders passed by the learned trial court as well as the learned first appellate court. Accordingly, this court, however, this court is of the opinion that as the suit has been pending for more than a decade, the said suit be disposed of at the earliest. This court therefore requests the learned trial court to dispose of the said suit within a period of 6 months from the date a certified copy of this order is served is placed before the learned trial court. And the learned trial court, if so necessary, take up the suit on day-to-day basis for a quick disposal of the said suit. With above, the instant proceeding stands disposed.
All right.
My trial court order is 6/9/2013.
Yes, what is this?
This project service complete, but no one appearing project and landlord tenant matter project. The landlord states that I am a license. So
You are landlord?
no, I am the
Then why is the landlord not appearing?
complete project as per of it.
Hello? Let me dismiss it without them. Lost to the lawyer.
As per project, the trial court dismissed the suit of the landlord court. Thereafter, on appeal, the first appellate court reversed the finding.
You are a landlord.
I-
Who is
my-
the landlord? Landlord, you are the tenant.
Yes, but my case is that lordship, I am a tenant under, and landlord case is that lordship, I am a licensed, so I pay it. I think I am a tenant lordship, I am rented service to the landlord in lieu of that portion lordship, which I am using since 1965. And the bakery shop which I have taken on rent, in respect to that I am paying rent. So their case is that as per that agreement, I am a tenant over some other property, but this person I am a licensee. The tenant's deed I have annexed. Annexed to lot.
Why is the service not, what is the effect?
Office notice their lordship at 12/5/2023. Usual son received and registered, the client he himself received.
Why is the amended memo filed?
Lordship, the original petitioner died, we have submitted.
Okay. Legal heirs of the petitioner. What's the idea of legal heirs of
Only
petitioner? I mean,
because it would lordship, it was not
service.
executed.
Where's the order here signed by the respondent himself based on neighbor? Service is complete.
Yes, but 12/5/2023. Of it.
And you have been held to be,
Licensee by the first appellate court and the trial court said I am a tenant.
okay. The licensee and the
PW already indicated that lordship are using the date
and the trial court holds it what?
lordship that it is a tenancy lordship.
Huh?
Trial court judgment page 31 lordship, issue number 4 discussed.
Hello, we'll call for the records. Without the other side appearing what to do. Okay.
By order dated 22/2023, notice was issued and stay was granted.
This court, having heard the learned counsel for the petitioner, is of the opinion that for an appropriate decision and for an effect for deciding this instant petition, the records of title suit number 1757/2015 as well as the records of title appeal number 5/2020 would be required. The registry is directed to call for the said records. This court further admits the instant revision application. List the matter again on. List the matter immediately upon receipt of the LCR for hearing.
Hearing order.
Interim order passed earlier shall continue.
Sandeep Dev.
Yes, Mr. Som.
The petitioners are the plaintiffs. Here, the petitioners are the plaintiffs.
Then further,
Their lordship, harder evidence that was closed.
How many times?
One PW has submitted and partly cross-examined.
then
Lordship, what happened in this case, earlier engaged counsel submitted before the learned trial court that the plaintiffs are not willing to adduce further evidence.
then matter ends.
On that ground, that was closed. Later on, new counsel engaged
You
lordship
can't go on. Then what to do?
and she has filed an application for
Which order you are challenging?
page 84, your lord. Type copy.
84. Today is fixed for an order on petition filed by the plaintiff for allowing them to adduce of them. Stated in the petition that the petition was filed earlier on stating that we have not been. Then what is the stage now?
Now, cross-examination of plaintiff witness.
How many PWs?
Only one submit adduced, lord.
How many PWs have been adduced?
Only one. Only plaintiff, Hogan, lordship,
Why the orders are saying PWs?
only one. Lordship, kindly see your lordship, page. Fifty-eight, start from page 50. Type. Order dated 3/4/2018.
So the DW has not yet
No,
been
no.
cross-examined.
Plaintiff witness also
Now
not
tell me where's your petition?
petition lordship, page 54.
Whom do you want to adduce evidence? Whom do you want to adduce
Lordship,
evidence?
four plaintiffs are there, lordship. The other plaintiffs maybe. Only one witnesses have been adduced. One evidence. Okay, plaintiff. Five plaintiffs are there.
No. This type of petition has been rightly rejected. Once the evidence is closed, you have to show what prejudice is being caused. What is the prejudice caused? For that, you have to show that these are the various witnesses we need to give. This witness will say this, where these person's
part of-
name were there
That
in the
part
list of
is not there,
witnesses. Huh?
but that part is
Did you
not there.
submit a list of witness?
That has already been submitted. That's why-
Then you don't know anything out here.
Lordship, kindly see the order dated page 59, your lordship, 5/6/2018, your lordship.
5/6/2018.
Page 59.
Hmm.
By that order, my PW.
Understood. Thereafter, you file this.
Thereafter, I filed this
You
application.
woke up on,
Yes,
this is in 18.
Lord-
You woke up on in 2020,
Lordship, I
just
have,
before COVID. Well,
I have annexed all the orders, your lordship.
I've seen the entire order.
My suit.
You don't have a case.
My suit, lordship,
You should, yes, but you have to show before the court and look at, yes, there was a mistake. But then also, he had made a mistake. But then also, these are the other witnesses which needs to be given. Why you want them? See your petition,
yes, yes.
page
lordship,
54.
I have seen.
Then should we exercise 227 out here? No. I hope.
Lordship, for the ends of justice.
There's no ends of justice. Ends of justice is just outside the door. Hope the counsel is going outside. You might get a glimpse out there, outside. It's not here. Ends of justice is there. Yeah.
Only the plaintiff.
This is an application under Article 227 of the Constitution. Challenging the order dated 7/12/2021, passed by the Learned Court of the Munsif number 2, Dibrugarh, whereby the application filed by the petitioner,
Petitioner.
by the petitioners under section 151 on 19/2/2020 was rejected. A perusal of the materials on record reveals that the plaintiffs had adduced the evidence of one plaintiff witness. Thereupon, on 5/6/2018, the counsel for the plaintiffs apprised the court that the plaintiffs do not wish to adduce further evidence. Under such circumstances, the Learned Trial Court proceeded with the suit, thereby fixing 10/7/2018 for the cross of the PW. 1. Full stop. It is, however, relevant to take note of that as on date, the cross-examination of the PW is not complete.
Is not partly.
This court have also taken note of the application filed by the petitioner, who are the plaintiffs, under section 151 on 19/2/2020. A perusal of the said application is bereft of any particulars as to what prejudice has been caused to the plaintiffs if further evidence is not permitted to be given. Or for that matter, the said application does not mention who are the other witnesses whom the plaintiff would like to allow, who would like to adduce, whose evidence the plaintiff would like to be adduced. Under such circumstances, this court finds no error in the order dated Where's that order?
7/12/21, Lord, 84.
7/12/2021, passed by the learned trial court. The learned next. Accordingly, this court finds no ground for interfering with the said order, more so in the proceedings under Article 227 of the Constitution. The learned counsel appearing on behalf next. The learned counsel appearing on behalf of the petitioner, however, submits that the counsel appearing on behalf of the plaintiffs, petitioners before the trial court ought to have given better particulars before the trial court as to whose evidence the plaintiff ought to have adduced apart from the PW1. He submitted that if such that taking into account that the suit has now not till date proceeded to the stage of defendant's witness, the petitioner may be permitted to file a fresh application giving due particulars, and in that regard, appropriate direction may be given to the relevant trial court to consider the said application. Taking into account, this court is of the opinion that such a submission, that this court is of the opinion that the dismissal of the instant application shall not preclude the petitioner, who are the plaintiffs in the suit, to file a application, fresh application, giving due particulars as to what other witnesses the plaintiff wishes to adduce and how their evidence would be relevant. If such an application is filed, this court such an application is filed, the learned trial court shall duly consider the same, if so permissible under law.
Acknowledge, Lord.
There's a stay.
No, Lord.
No stay.
No.
Then the said permission to file such an application is subject to the suit having not proceeded to the stage of defendant witness.
Acknowledge, Lord.
Yes, Mr. Ali.
My lord, before my learned friend starts, and
Yes.
with your lordship permission, my lord, what I just request that not for an adjournment of this matter, is that if whether there can be a try for mediation of this particular case. Why? My lordship once held this particular case by a regular second appeal. Regular second appeal lordship is held this matter. They file one Bhawarilal file a suit. Just 2 minutes, my if your lordship permit me, man. He filed a suit telling that he has purchased the particular suit land by sale deed from predecessor interest of the defendants. Now, in this manner, summons were issued, defendants appeared, they file a counterclaim against the suit, and their case is that counterclaim is the sale deed is fraudulently has been executed. Ultimately, it was heard, evidence was adduced, and ultimately, the suit was dismissed and it was the counterclaim was allowed. That means decreed in their favor. Against that, they filed a regular second appeal for this. For the first time, in your lordship judgment, a submission was made by the Bhawarilal Council at para 34, stating that in the meantime, when the suit was pending, there was a building which has been constructed, multi-story building. Your lordship judgment said, why we are concerned? We are not concerned about that, because section 100 restricted to regular second appeal. We'll decide to that extent. We are not deciding those issues, whether it is not our headache to decide about that, whether multi-story building, and that's the first time which was raised by the Bhawarilal Council before this court. And
But who are you?
I filed an application. In the meantime, what has happened during dependency, multi-story building was constructed. We purchased those 17 particular flat owners are there. We have 4 numbers where we filed.
Is that the application where Mr. S.P. Roy was there?
Yes, correct. Right.
Yeah.
Then we file an application under order 21, rule 102/97/99.
How do you file it?
Now, my lord, that we filed it with that. We said that 52 of the transfer of property. There is a fraud
How
which
do
has
you
taken.
file it?
I filed.
No, you can't file that. You are persons who come within the ambit of that person. You are claiming your title from those persons. Then how do you file this app?
But my lord, the question is that we were not aware of the proceeding, my lord.
Not necessary.
We were not aware of the proceeding.
Your right, whatever is from there.
But that's true. But this one we were not in. We doesn't know about it. My lord,
You don't know that is the material.
My lord,
That is the material, but you claim your right from them.
sale was effected, my lord. Due permission was granted. We have taken loan for that.
Whatever
Only
may
what-
be, that's
what
the
I-
different thing. Has the building been destroyed or not? Demolished or not?
No, my lord. That's because
Not
there
till
was.
now.
I just, my lord, my humble submission is that, my lord, ultimately, end of the day, my lord, if it goes for
Rules
mediation, that
not
will be.
applicable to transferee pendant line.
That's
What you-
your lordship is right.
Then
What I'm
how
saying-
could they learn it? The trial court decide all this?
No, my lord, what my case is about section 52 of the transfer of property Act. My lord, ultimately, end of the day, they will come and this is the price they want. So ultimately, my lord, one chance, just, my lord, if you sit with them for a week, my lord, mediation.
Okay.
Mediation.
The mediation room out here in Guwahati High Court is in a horrendous state. The mediation room in the trial court is in a better
No,
state.
I
of
don't
affairs.
mind, my lord.
So these petitions require to be allowed. You go there to do what mediations are. This is nothing, no business out here. How can this type of orders, the court having not taken into account the order 21 to 102, isn't that your case? That's your case. Yes, I remember. How can these people who claim their right, their pendant line transferees? The trial court, the executing court did not take into consideration this statutory provision.
Let the learned trial court decide, then, my lord. Fresh, my
Executing court.
executing court.
What is there to decide? Your applications are not maintainable.
But my lord, I just want your lordship. That's your lordship of the issue. 1, 2, 3 judgments. Just because ultimately that's the very narrow campus the matter is about. Whether it can be maintainable on the ground because of there is a bar under 102. That's what your lordship is saying. I'll just show one particular. I have heard that other judgments is not like Guwahati High Court precedent that will follow, not about the other judgment, except in the judgment of the Supreme Court. That's also I have got to a judgment.
Sometimes those judgments of Supreme Court is for the Supreme Court.
One judgment, my lord. We
Sir,
were-
Eka, were you not appearing against me in that matter before the Serene matter? The trial court? And then the matter came before the High Court. You must have seen that what the provision that I've seen.
Right. One judgment just I just lordship for me. Because very narrow campus the matter is about. Only what was your lordship is right legally, but what will this be building, my lord? Entire we purchase. If your lordship kindly see, para 11, if your lordship kindly para 11. Itu dada calculation, किमान है तो 2009 SEC online Punjab and Haryana 695. May I just read 11 mile? 11. Just
This is a different aspect. I don't know why this court has passed this order. But what is required to be done is different. And I am not sitting out
I-
here to advise what is.
No, already we have raised fraud in this case, my lord. Collusion, sorry, collusion, we have raised collusion.
So, it's a case
No,
of
it-
fraud and collusion.
no,
You
it
know
is a
what should be
collusion.
done.
No,
25
collusion,
years.
my lord, collusion, my lord.
As you know, if it's a case of fraud or collusion, you are alleging or anything, what's to
Collusion.
be done?
But it can be, instead of filing.
The
in-
provisions of, you see, the why I'm saying it. The provisions of Order 21, Rule 97 to 105 would not apply if it is a case of fraud or collusion. Do I need to say anything more?
No, your lordship, that proposition is there. But substantive law under 52 of the Transfer of Property Act, that's our limited case. my lord.
Again, yes, repeating. You know what is to be done. Can I give more further indication?
No, there's separate suit. Well, I understand, my lord.
That is why when the matters out there's the 1998 or 97 judgment out there after the Silver Line judgment. A question came up out there with regards whether those suits, a suit pertaining to a same property would be barred. Then the Supreme Court says it would be barred at the 7 rate with Order 41, Rule 97 to 101, 105, provided it's not a case of fraud or collusion. What else do I need to say? But you knew it. Open eyes. But here these
only-
cases are to be dismissed, right?
Only what is the
Allowed. These petitions are to be allowed.
my
High Court
collusion?
doesn't know
So
102.
the pollution,
lord.
your lordship, a party who has filed the matter, your lordship, for 25 years up to Supreme Court.
Hmm.
How there can be pollution, your lordship?
Collusion,
Yeah, that's a
Has it been
different
a
thing.
case, your lordship?
No, they
No,
are
no,
alleging.
here
I am
is-
not saying
There is
anything.
limit to allegation, your lordship. Pollution, mere using the word pollution, your lordship, does not make the matter pollution, your lordship. Pollution is a different thing, your lordship. Has it been a case, your lordship, that somebody has conceded to the illegal demands of the other party? Conceded. 25 years, your lordship, from beginning to end, your lordship, Supreme Court. Now it says pollution is there in between their builder as well as the plaintiff who has lost the suit in all the stages of the case, your lordship, in all the matters.
Yeah,
Now, I
good. Your
don't-
good case is Priyanka.
that I know, I don't know.
You go do the whatever the Supreme Court said on the Priyanka's judgment and said that okay, you file a case against the Sikaria person.
But
Against
Priyanka,
against respondent number 2.
Yeah.
But,
Nothing has been done, your lordship.
collusion, this has
They are
not
in
been,
collision. Actually, collision
only
is
a
in
prima
between-
facie observation has made by the learned, the trial court saying that it is a prima facie observation is a matter of evidence. That's all, my lord.
No
It's a
question,
matter
there
of
is
evidence.
additional-
Whatever may be, the trial court, executing court was wrong in taking up your application. It could not have. You were transfer dependent lives. 102 is applicable. Isn't that your case?
I think that is this 2008 7 SCC 144. It is clear, your lordship. It is Sasina versus Yuram.
That only
Clear
2008,
cut
my
case.
learned friend, which is the judgment.
Whether
has
they
been
know
Usha
it or
Sinha,
not,
that has
not
been
your
just
lordship.
a
It is
distinguished in
immaterial.
Punjab and Haryana High Court, my lord. With great respect.
now you are in the High
With
Court.
great respect.
With great respect, this is for Punjab and Haryana to look into.
Please allow me to, because I'm addressing the
No,
court,
you are
not
addressing,
addressing.
not that.
Not addressing.
No,
you.
no, no,
Yes,
there's nothing out there, Mr.
I'm addressing the court. I'm not
Mr.
addressing.
Ali,
Does not
Mr. Ali,
Yes,
that day my matter was taken up by this court on that date. You wanted to do it just before 21st. I said that I won't be there. So this matter has been fixed today. So I remember that matter. Your simple case is Order 21, Rule 102 apply. And if 102 applies, the question of entertaining that application does not arise. That's your case. But your submission is duly.
Only just for my satisfaction. If
He
you-
wants to submit that on account of if it is a case of lis pendis, it does not apply if it is a case of collusion. Meaning there is a collusion between the builder and you.
It's a question of fact.
No.
That's
No, wait, let me say. The builder and you, there is a collision of it. So if there is a collision of builder and you, that is a case of cannot be done under 102.
Correct.
It has to be done by any other matter, which I would not partake. Hello.
My
Let
lord,
me
just only
dispose of.
for my lord, para 12 of Punjab and Haryana, my lord, only for my section, one
What?
paragraph. Paragraph.
No.
Paragraph.
Mr. That is too much. It is too much.
That particular, then my lord, suit to be filed, that's your lordship, just 2 minutes, my lord, suit to be filed. But again, one judgment of the Bombay High Court said, the parliament has registered 52 also, only that it doesn't get delayed. In an execution proceeding also, it can be brought up. That's what it says, man, what I've understood. Only
That
it's a
is why, you see, 52 has been brought up only for the purpose that if you make any transfer during the pendency, those will be subject to all. That is why 102 has also been brought in. But you cannot
but
raise.
52 comes an exception, my lord.
Absolutely, the
Yes,
52
comes
will
in
come here.
exception and the
It's not an exception. The 50, because of 52, you get involved. Otherwise, it could not have been imposed. The decree could not have been effected or executed against you unless you don't have 52. That is why 52 is there. Otherwise, you may file a suit against Mr. Ali may file a suit against you, and you sell it to Mr. B. Deka. And if 52 is not there, he cannot execute the decree against him. Because of 52, this is there. And 102 bars Mr. Deka to come and say that if Mr. Das has done wrongful things in collusion with Mr. Ali, I should be spared.
No, if the suit is, my lord, is only if it is collusive. Here we said, this is what we are saying. It is only a matter of evidence. If it is not collusive, that's a difference. This is what-
Understood this collusion aspect, if it is there, if it's a case of fraud or collusion, the decree becomes a nullity. That is why you need no, you cannot. It does not come within the ambit of Order 21, Rule 97 to here. If you may bring it under 47, that's another aspect of the matter. But not under Order 21, Rule 97 to 105. Remember that. 47 is a different aspect. But 47 is on a very thin line.
That's right. That's the reason. My
So you
lord,
can't come under Order 21, Rule 97 to 105. No, you can't. You may go under 47, but it is a very thin line. But going under 47, you have to be subservient, holding. It is something like a quashing proceedings, holding everything to be right. Then also you can't execute it.
That's the whole problem, my lord. That's
So the
47 is
only
very-
way out is don't say for this court to give you an advice.
Actually, they have actually misconcepted the judgment and decree. Judgment and decree is for the land. And during the pendency, he obtained an injunction against me, your lordship, against the defendant, counter claimant, that he should not be allowed to disturb me while I will be constructing. That way he devoured me, your lordship. He restrained me from interfering with the construction, which is known to them, your lordship. It is not to them. Now the decrease in respect of the land, I want the land that is 2/17 lesser. If for that purpose, your lordship, is a flat, units or whatever may be there, your lordship, either it should be demolished or they are to stand that. Simple matter, your lordship. Simple. There is no asas, your lordship, that this way there is separate suit does not like your lordship. On number of occasions, your lordship, it has been held that no separate suit lies, your lordship. No separate suit lies. So they being the lordship custody, they are bound by the judgment and decree because they have no independent right and right over it. Without the independent right and right in your lordship, they can't raise any objection. They are bound by the decree because their claim is entirely through the judgment. So equally they are judgment in law.
And kindly see paragraph 34 of my judgment at page 121. This court duly deals with it. First of all, this cannot be a substantial question of law. And secondly, whatever has been done as regards anything will be always subject to the litigation.
Correct.
And what happened? No appeal. Supreme Court,
Yes.
we are inclined to interfere, not inclined to concurrent finding and leave it dismissed. So matter and very well.
Now they have come to negate the entire judgment and take it from
Ah.
bullship to a lot of Supreme Court.
Let me come back.
Supreme Court.
Yeah.
So what is this?
Now, yeah, let me come back now. Just give me a good idea as to how to impose cost upon them in that case for filing unnecessary. I'm coming in.
Plot.
Bye.
Submission. Just two submission I just to make.
Hmm.
My submission before your lordship is that 102 is a facet of 52 of the Transfer of Property Act.
Hmm.
It's because 52, if your lordship kindly see 52 of the Transfer of Property Act. Just read 52 man.
Yes.
During the pendency of in any court having authority within the limits of so and so, established beyond such limit, the suit of which is not collusive and in which any right to immoral property directly and specifically in question, the property cannot be transferred, otherwise dealt with by any party to the suit or proceeding, so as to affect the rights of any other party thereof, thereto under any decree or order which may be made therein, except under the authority of the court, and on such term it may impose. So our whole case, if your lordship looks into our case regarding about the application which has been filed before the learned trial court at page 125. My lord will kindly see at para 14 mile. Para 14 at page 133. That the petitioner begs to state that the opposite party number 7, who himself was a plaintiff in the original suit, has never disclosed.
Eight.
Page 133, my lord. My lord, para 14. That the petitioner begs to the opposite party number 7, who himself was a plaintiff in the original suit, have never disclosed the facts about construction of multi-story building complex, and had also never prayed for amendment of the pleading with a view to disclose about the construction so made and the sale made in pursuance thereof. Moreover, the opposite party number 126, who are resident of Pennsylvania, which falls under the same locality and within radius 2 km, who stake their claim of ownership over the suit land as a counterclaim, and never preferred any application to bring on record the construction and sale activities of the opposite party number 7 being undertaken over the suit land.
When was the counterclaim filed?
I'm sorry.
When was the counterclaim filed?
Counterclaim was filed. This your lordship will find the count 10/1/1998.
And when did you enter?
They're different date thereafter.
Then?
Yes. Now, my lord will just look into it. My lord, two more paragraphs at 134 is para 15. That a petitioner begs the opposite party has abstained themselves from disclosing the actual status of the suit land in order to deprive the prospective buyers of the hard-earned money which had invested by purchasing the flat in Sevota complaint. 16, my lord, that the petitioner begs to set the opposite party in collusion among themselves is refrained from amending the pleading and schedule of the suit to deprive the prospective buyer of the residential flats. 17, my lord, that the petitioner further begs.
Whatever may be, Mr. Das, the question arises as to whether you are third party.
No, that's true, my
No,
lord.
no,
I'm
a third party.
Now, my lord,
You are claiming the rights under them.
they file an
And if I remember correctly, at that point of time, there was an injunction. Then also there was some construction being carried out. This construction was in violation to that.
My lord,
So your lordship,
I'll just finish, my lord. One,
physically and verbally, actually, the construction was resisted by us. But we obtained the injunction from the court, your lordship, that I prefer to edit. So that way, your lordship, we went to the construction, your lordship, we were from.
injunction was against them, my lord. If your lordship kindly see at page 172, the order that has been passed by this court, by the trial court at 178.
Yes.
Lordship got it, mine. That's the second paragraph. Under the aforesaid facts, but the petitioner has no occasion to believe that his purchase flat has been encumbered or litigated any manner. In view of the above, learned counsel petitioner submitted petitioner has been prima facie able, judgment and decree so and decree pass are collusive in nature, and as such petition file a petition under order so and so, thereby challenging the aforesaid judgment on the ground of fraud is maintainable. In this respect, learned counsel with third party relied upon judgment so and so, judgment and decree obtained by playing.
If it's a case of fraud, order 21, rule 101 to 105 does not apply.
So only my argument before your lordship is 102 is a basis of 52. And if your lordship, see, that's a specific averment which has been made in the before the learned trial. Now, my lord, I'll just show. It's just with your lordship permission, my lord. 2 paragraphs I'll just read of the judgment of Punjab and Haryana, my lord. Kindly allow me. Then, my lord, your lordship will just pass order. At paragraph 11, my lord. Paragraph 11 of the Punjab. According to the above position, the expression provided in section 52 is of the rule of least pendant shall not apply where the suit or proceeding is collusive, meaning thereby the section shall not apply if it is proved by a person resisting the position that the decree which is sought to be executed has been obtained by the decree holder is a collusive one. Since the question involved in the execution whether a decree is collusive or not is a question of fact, then it has to be tried like a suit for which the executing court should have framed the issue specifically when in objection the appellant is considered as under. Now, if you see there 12 is the facts of that case. 12 judgment relied by so and so another respondent are altogether on different facts in view of order 21 rule 102 CPC that the objection are not supposed to be decided like a suit and can be adjudicated upon summarily. Because of the present case, once there is a categorical allegation containing that objection decree which is thought to be executed has been obtained by collusion by decree holder with the judgment debtor, the provision of section 52 of Transferring Property Act shall not apply, and the court has to educate these facts after framing an issue in this regard and give proper opportunity to both the parties to lead their evidence. This is exactly what we made the application before the learned trial court. And if there is an observation which I read by the learned trial court, prima facie as case has been made out. One judgment like to before this court, my lord.
Now, what is the collusion between that Bhanwarilal Sharma with them? What is the collusion?
That will show in the evidence file.
No. What is the collusion? You tell private. What is the collusion?
No, Dave, our clause is that
From your application, which you have,
No.
the averments which have been made does not show any allegation of collusion.
no, but they never, my lord, we were not aware of it. Neither, my lord, the meaning thereby there was no amendment because the schedule of the property which has been made in the counterclaim is only in respect of Godown. Lordship will kindly see it. We were not aware of it also. Collusion means they neither amended the pleading.
Why?
They
Why is
have
it
not
necessary?
amended. Because in the
Is it
meantime,
necessary every time to amend it?
my lord, what we are saying, our whole case is that your lordship is putting
Every
a
time
query.
you keep on changing, is it necessary?
Your
No.
lordship is putting a query to me. What is a collusive? What is a collusion? My answer to that is that we were not aware that what was going on between the plaintiff and the defendant.
No.
That's what, my lord.
No. The decree has to be obtained collusion between the plaintiff and the defendant in order to bring you within the ambit of the collusion. Where is show me, the allegation is not there. In your paragraph number 14, 15, and 16 of your
16, my
application.
16.
No,
Paragraph-
that is not the allegation that he has collusively obtained it.
My lord, if your lordship kindly see paragraph 16, my lord. Paragraph
When did you
16.
enter into an agreement first?
I'm sorry.
When did you enter into the agreement first
With the
with the builder?
with the
2005.
2007, 8,
Eight.
or different.
In the meantime,
2007.
the trial has already begun. When was the trial court judgment?
Trial court judgment
It is
was passed on.
25/9/06.
Then you came into picture only in the first appellate stage.
My lord, we got a no litigation certificate also.
So what?
That's the whole problem, my
No litigation
no
certificate.
litigation certificate.
No litigation certificate. If you have got it, ask the filer suit for compensation against those people who have given you the no litigation certificate.
Committed real fraud against you.
That's the whole problem. We invested huge amount of
For
money, my
that,
lord.
they cannot lose.
And the what has been done, my lord, regarding about the property. My lord, one judgment I like to quote for your lordship is 2013 Bombay, 2013 SCC online, Bombay 1644.
Hmm.
Division bench judgment, my lord. And it's division bench judgment, my lord.
Yes. What does it
Court
say?
And if your lordship sees para 8, my lord. Lordship got it, para 8. We have indicated the basis and foundation of which the appellant has claimed title to inborn property. We are not called upon at this stage to evaluate. Appellant established a title of property since in our view. It was for the learned signature in the course of the execution proceeding to educate the upon the question once the appellant has sought a lifting of the attachment on the ground that it was appellant who had title to property. Such a claim in the course of execution cannot be disposed of summarily. A claim of this nature cannot be asserted by way of independent suit, but has to be raised in the course of execution proceeding. Order 21, Rule 101 of the Code of Civil Procedure, all question, including the question relating to right title to interest in the property arising between the parties proceeding on an application under Rule 97 or Rule 99 and relevant to the adjudication of the application shall be determined by the court dealing with the application, not by a separate suit. The meaning and purport of this suit under
Mr. Das, this is a judgment where he claimed an independent title beyond the plaintiff and the defendants. Here it is not. You are claiming the title from the plaintiff. No doubt that proposition of law is there. There's no quarrel with that proposition.
of law I was trying
That
to-
proposition of law is there, but you don't claim an independent title. You claim the title on the basis of the plaintiff or the defendant, whoever may be.
must be only summarily whatever the proposition.
Summarily,
is
100%. If it is not applicable,
Summarily, it should be. That's what our case.
rightly
proposition of law.
so.
My lord, the Supreme Court observed that after referring to earlier in the provision of so and so have been widened and liberally construed to enable the executive court to adjudicate the inner se claim of decree holder, third party in the course of execution to themselves to avoid prolongation of litigation by driving parties to independent suit.
No
That's
doubt
what-
there is problem. There's no
That's
problem.
what only proposition of law I am trying to show, my lord.
No.
My lord will kindly see in interpreting the provision of Order 21, Rule 97 of the Code and other provision of the state order, the aims and object for introducing amendment to the code cannot be lost sight of the under the unamended code. Third party adversely affected or dispossessed from the property involved were required to file in for claiming title. The legislature purposely amended provision in Order 21 to enable the third party to seek the adjudication of the rights in the execution proceeding themselves with a view to curtail the prolongation of litigation and arrest delay causing execution of decree. Having regard to the well-settled position of law, we are of the view that summary manner in which the learned single judge has dealt with the chamber is untenable.
Kindly come to Silver Line Forum the
Yes.
judgment of a three judges bench, the Supreme Court. Paragraph 10, 9.
Silver Line Forum.
Yeah.
Private limited.
Paragraph 9.
Paragraph 9.
Paragraph 10.
Paragraph 10.
Yeah.
It is true. It is true that Rule 99 of Order 21 is not available to any person until he disposes of immovable property by decree holder. Rule 101 stipulates all questions arising between the parties to a proceeding on an application under Rule 97 or Rule 99 shall be determined by the executing court if such questions are relevant to the execution of the application. A third party to the decree who offer resistance would thus fall within the ambit of Rule 101 if an adjudication is warranted as a consequence of resistance or obstruction made by him to the execution of the decree. No doubt, if the resistance was made by transferee penalty of the judgment debtor, scope of the adjudication would be strong to a limited question whether he is a transferee, and on a finding in the affirmative regarding the point, the execution court has to hold that he has no right to resist in view of the clear language contained in 102. No, but here there was no collusion, provided
See, the next thing, exclusion of such a
Exclusion of a
transfer
transferee
from raising
from
further
raising further
contending
contest
based on the salutary
salary
principle.
principle abrogated
Then
and in section 52
Yeah.
of the transfer.
that is the reason why I'm saying you cannot raise that. Only way you can raise it by way of a collusion, fraud, and you know what to do.
Collusion is again.
But your allegations which are there, these are
collusion,
far.
collusion is again with respectful submission is a matter of evidence.
No,
That's what.
collusion you have to cannot raise it in a proceedings under Order 21 Rule 97 to 101. You cannot. That can be only raised. If it is a collusion, it amounts to a fraud. And if it is a fraud, then a decree, if any decree is passed, is a nullity.
That's
So
But
that is a
our-
question. If it is a nullity, how do you take care of that? Either on the thin line under 47, which is depending upon what you want to do under 47, or under the provisions of whatever new. Hello.
that's all.
Lahore. All the four side, there are four
Four,
proceedings.
my lord.
Lordship, one decision I'd like to cite.
Why? I'm in your favor. Why?
No, Lordship, is the just really exactly on our system.
To put a what you call death knell.
Correct. 102 itself.
And this is what the silver line they have further progressed with silver line.
Para 18, it is very clear. Para 18, the lot.
Paragraph 23,
Para 18, 1
paragraph 23.
lot. 23 is
It is thus well settled that a purchaser of a property during the pendency of a litigation has no right to resist or obstruct execution of a decree passed by a competent court. The doctrine of lease pendens prohibits a party from dealing with the property which is the subject matter of the suit. Lease pendens itself is treated as a constructive notice to the purchaser, and he is bound by a decree to be entered in the pending suit. Rule 102 therefore clarifies that there should not be resistance or obstruction by a transferee pendent light. It declares that if resistance is caused or obstruction is offered by a transferee pendent light, he cannot seek the benefit of Rules 98 or 100 of Order 21. And in fact, why it is so that you, Mr. Ali, if you see the explanation to Section 3, of the Transfer Property Act, where in its case, it says that you have due notice
Correct.
in respect of an immovable property, and therefore any person who claims any right or has claims any right on a property which is a subject matter of litigation, he has or any litigation will have constructive notice.
Sir, may I draw this 25, your lordship? It's small fact,
25. Yeah.
small fact,
Yeah.
25.
We are in respectful agreement with the proposition of law laid down by the Supreme Court in Silver Line Forum. That is what I said. No,
Lordship, in our opinion,
In our opinion, the doctrine is based on the principle that the person purchasing the property from the judgment debtor during the pendency of the suit has no independent right to the property to resist, obstruct, or object
Correct.
execution of the decree. Resistance at the instance of a transferee of a judgment debtor during the pendency of the suit cannot be said to be resistance or obstruction by a person in his own right, and therefore is not entitled to get his claim
so
adjudicated.
this resistance is still at their instigation. They have set up this persons, your lordship.
Yes.
That I have failed in all stages. Now you start another battle, your lordship, and let it be decided by the
Anyway.
court after taking 10 or 15 years.
Now can I dictate? The four applications under Article 227 of the Constitution are taken up together for disposal, considering the common issues involved in the proceedings and arising out of the same execution proceedings. I've heard Mr. S. Ali, the learned counsel, appearing on behalf of the petitioners, and Mr. D. Das, the learned senior counsel, assisted by Mr. B. D. Decker, appearing on behalf of the respondents in all four applications. For deciding the nature of the instant application, for deciding the application, this court finds it relevant to take note of briefly the facts leading to the filing of the instant applications. The petitioners herein, as plaintiff, the predecessor in interest to the petitioners herein, as plaintiff, had filed a suit which was registered and numbered as title suit number 223/1997. The brief facts of the said suit was that the plaintiff had purchased a plot of land measuring 2 kathas covered by Dag number 1107 of KP Patta number 661 of village Chatribari by the registered deed of sale bearing deed number 7213 dated 30/11/1992 from one Rukman Ajitsaria since deceased. The said Rukman Ajitsaria was the husband of the defendant number 1 and the father of the defendant numbers 2 to 5 in the said suit. Thereupon, the plaintiff had taken possession of the entire suit land measuring 2 kathas 17 lectures and got his name mutated in the revenue records, and the structures standing thereon were duly assessed in the name of the plaintiff. On 25/9/1997, the plaintiff came to learn that the defendants mutated the name in respect of 17 lectures of land as the legal heir of the original pattada of Rukman Ajitsaria.
He defended this present petitioner, your lordship.
Hmm?
He defended your lordship. He had a present petitioner.
Defendants are
Because the respondent number 2 filed is suit. This Banwarilal, your lordship, respondent number here 2. He filed his suit, your lordship. We were defendant counterclaimant.
Okay, okay. Itu aku ini kan. The brief facts leading to the filing of the instant application are that the respondent number 2 herein had instituted a suit being title suit number 223/1997 seeking a declaration that the defendants had no right to evict the respondent number 2, that is the plaintiff, from the suit premises as described in the schedule to the plaintiff without following the due process and for permanent injunction. The scheduled land, as they mentioned in the said suit, was 2 kathas 17 lectures of land covered by KP Patta number 661 of Dag number 1107 of village Sohor, Guwahati, Dutiya Khonda, second part, Moja, Guwahati, wherein houses were standing thereon, bearing municipal holding number 388 of ward number 13 of GMC. The defendants in the said suit who are the petitioners herein filed a written statement cum counterclaim denying the allegations made in the said suit and further seeking that the defendants had right, title, and interest over the suit property, semicolon, for declaration that the sale deed number 7213/1992 dated 30/11/92 was fraudulent, collusive, and void ab initio, and the same did not confer any right, title, and interest upon the plaintiff, the respondent number 2 herein, over the suit property or any part thereof, and for delivering up and cancellation of the said deed, semicolon, ejectment of the plaintiff, the respondent number 2 herein from the suit property, semicolon, recovery of cast possession of the suit property to the defendants by evicting and removing the plaintiff, the respondent number 2 herein, and all his men, materials therefrom, semicolon, permanent injunction restraining the plaintiff and his men, agents, servants, workmen from entering into the suit property and from interfering with the peaceful enjoyment and possession of the defendants over the suit property, semicolon, recovery of rupees 1 lakh as compensation for the wrong done to the godown house on the structures on the suit land, for issuance of precept, etc. On the basis of the said suit, so filed as well as the counterclaim, as many as 7 issues, as many as 6 issues were framed, and the frame was after adducing of evidence by the parties, the learned trial court, that is the court of the civil judge number 2, Kamrup Metro at Guwahati, by a judgment and order dated 25/9/2006, dismissed the suit and decreed the counterclaim of the plaintiffs of the defendants oblique the petitioners herein. Being agreed, an appeal was prepared which was registered and numbered as title appeal number 109/06 before the court of the district judge Kamrup Metro at Guwahati. By the judgment and decree dated 15/9/2007, the said appeal was dismissed by affirming to the judgment and decree passed by the learned trial court, being aggrieved. The respondent number 2 herein preferred an appeal before this court, which was registered and numbered as RSA number 56/2008. At this stage, it is very pertinent to mention that the respondent number 1 in CRP number CRP IO 197/2023 purchased all these purchases were subsequent to 2007? Again, appeal was dismissed by the judgment and at this stage, this court finds it very pertinent to take note of a development which took place
Is 2001 also there?
during the pendency of the suits and the appeal. Roman 1. The petitioner, the respondent number 1 in CRP IO 197/2023 purchased a RCC roof with super built up area with roof casting measuring 1307.6 square feet marked as 303 on the third floor of Sewada complex together with parking space marked as parking area number 303 by the registered deed of sale bearing deed number. What is the deed number? 10. Deed number 10558/08 dated 31/7/2008. The said respondent further, respondent number 1 further purchased another area measuring 1404 square feet marked as 304 on the third floor of Sewada complex together with parking space marked as parking number 304 via a registered deed of sale bearing deed number 10561/08 on 31/7/2008. Roman. The respondent number 1 in CRP IO number 198/2023 by the registered deed number 270 03 oblique 2703 oblique 01 dated 23/2001 purchased an RCC super built up area with roof casting measuring 1307 square feet The said respondent, number one, also purchased a residential slab oblique roof measuring 1307 square feet of super built up scale. Why there are the two are same? Why are two same?
For the land, your lordship, that is the ratio of the land, your lordship, which they will have right over each other, the case of future effect. And the other one is your lordship, that is the roof area, or the unit or the flat.
No, understood. But why both are same?
It is supposed to definitely advise your lordship. Go by the way.
It is the same. It's the same thing. It's been purchased twice.
Like,
Only see here. It's the same 1307 square feet. Why the respondent number one further in CRP number, the respondent number one further purchased the same area being flat number 403 on the fourth floor along with proportionate interest in respect to the land. By the deed of sale bearing deed number 166/2014 on 7/1/2014. Yes, you are appearing for them. Why these two?
But page 163 doesn't mention the floor and the unit number, but 172 mentions 403. And I'll have to check whether these are two separate units.
It's the same. It mentions the same thing.
The area is same, but the floor and the unit numbers are not available at 163.
It's flat number 403. See,
That number is not mentioned perhaps in the first thing.
then the car parking is the same.
Car parking is could be the same, but that number is not mentioned.
Area is also the same.
Area is also.
There must be some reason given. The consideration is also the same. 2,53,000.
Apple is so that's 403 as per the list.
This court had put a specific query upon the learned counsel appearing on behalf of the respondent number one as to what is the difference between the two deeds of sale. Taking into account the similarity in Schedule B with of the deed of sale bearing deed number 2703/2001 with Schedule B of deed number 144 Nikki. The learned counsel appearing on behalf of the respondent number one could not give a proper explanation to the same. Number three. The respondent number one in WPC number in CRPIO number 199/2001 had purchased a flat being number 401 measuring 1368.6 square feet in the multi-story complex in Sevada complex on 2/3/2021 or 2001? 2001 or 2021?
What about your
2001. The number is wrong. Number. On 2/3/2001 by the registered sale deed of sale bearing deed number 1892/01 dated 2/3/2001. The respondent number one next. The respondent number one in CRP number 19 IO number 196/2023 had also purchased a flat being number 103 measuring 1307 square feet in the multi-story complex in Sevada complex on 2/3/2001 from the this one. 2003 by the registered deed of sale bearing deed number 1893/01 dated 2/3/2001. The above constructions, the purchase which have been made by the respondent number one in the 4 revision applications were purchased during the pendency of the suit and the counterclaim. Were purchased post the filing of the suit as well as the counterclaim. Next. Moving forward, this court finds it very pertinent to take note of that on 13/5/2022, this court, via detailed judgment and order, dismissed the said regular second appeal number 56/2008. Was- This court also finds it very pertinent to take note of that the learned trial court, while deciding the issue number 4, 5, and 6, had duly taken note of that taken note of the submissions were made by the counsel for the respondent number 2 herein, who is the plaintiff, that during the pendency of the suit, the plaintiff had sold 20 the flats to 20 flat owners. The learned trial court also had taken note of that an application was filed by one of the flat owners seeking impediment which was rejected by the learned trial court by an order dated 10/5/2006. The learned trial court further observed that the dispute in the suit and the counterclaim was in relation to the land. And at the time of institution of the suit and the counterclaim, the building was not in existence. This court also, while dismissing the second appeal, had taken into consideration the submission made that during the pendency of the suit, a multi-storied building was constructed whereby various flats have been sold to the individual owners. And it was opined that as the construction of the building was carried out during the pendency of the litigation, and as such, any change brought to the status of the property shall be always subject to the result of the litigation. Pursuant to the dismissal of the second appeal, a special leave to appeal was filed before the Supreme Court by the respondent number 2 herein, which was dismissed by an order dated 1/8/2022. Subsequent thereto, a title execution application was filed by the petitioners herein, which was registered and numbered as title execution number 17/2022, seeking the assistance of the court for execution of the judgment and decree passed by the learned. Execution of the judgment and decree passed by the court. In the said title execution case, being title execution number 17/2022, 4 individual applications were filed by the respondent number 1 in the instant 4 revision applications, which were registered and numbered as Ms. J case number 775/2022. What are the numbers?
939.
Huh?
My lord has in CRP 196, Ms. J case number 939/22.
Number kita tak.
I'll give a
Miss Arata says 776/2022. Kita file. Huh? Impugn order to court letter.
776, 777, 778, and 779.
775, 776, 777, 778.
Right.
777 is there.
777, I think.
Now there will be only 4.
This 4.
So 775, 776, 777.
and 939.
And 778, your lordship.
It can't be too many. Anyway, cycle. Challenging the execution of the decree primarily on the ground.
Lordship, the last one is 939/20.
Challenging the execution of the decree primarily on the ground that the decree obtained by the respondents, by the petitioners herein, who were the defendants, was a collusive decree. Wherein the petitioners herein, wherein the applicants, that is the respondent number 1 in the 4 revision applications, instant 4 revision, were not made parties against the said application. Written objections were filed by the petitioners herein, challenging the maintainability of the said applications, specifically in view of the mandate of Order 21, Rule 102 of the Code. The learned trial executing court, that is the court of the civil judge number 2, Kamrup Metro at Guwahati, while the impugned orders, separate impugned orders, held that notwithstanding the bar contained in Section 52 of the Transfer of Property Act 1882, as well as Order 21, Rule 102 of the Code, the petition so filed, the application so filed by the respondent number 1 in the 4 revision application, the respective applications filed by the respondent number 1 in the 4 revision application were maintainable as the said respondent number 1 had prima facie was able to establish that there was an element of fraud played upon them while executing the sale deed in their favor. And on the basis thereof, opine that the petition filed by the respondent number 1 in the respective petitions filed by the respondent number 1 in the 4 applications were maintainable. It is under such circumstances the respective orders being passed in this case number so and so, so and so, so and so, by the order dated so and so, it's the same day, by the order all dated so and so, have been assailed in the present revision applications. I've heard the learned counsels appearing on behalf of the petitioner, Mr. S. Ali, who submitted that from the very applications filed by the petitioner, by the respondent number 1, herein, it is clear that they have purchased the said property, the property, the flats, during the pendency of the suit. And as such, they are pendant-like transferees for which there is a specific bar under Order 21, Rule 102 of the Code. And consequently, the applications so filed, the respective applications so filed by the respondent number 1 in the various in the 4 revision applications, instant 4 revision, are not maintainable. The learned counsel referred to the judgment of the Supreme Court in the case of Usha Sinha versus Dinaram and others, reported in 2008, 7 SCC 144. Anything else? On the other hand, Mr. D. Das, the learned counsel senior counsel appearing on behalf of the respondent number 1 in all these applications, in all the 4 revision applications submitted. That the respondent number 1 had purchased the said flats without the knowledge of the litigation. Referring to the application filed under Order 21, Rule 97, 99, and 101, the learned senior counsel submitted that the builder, that is the respondent number 2 in all the 4 revision applications, who was the plaintiff in the suit, did not disclose to the respondent number 1 about the pendency of the litigation. He further submitted that the petitioners herein, who were the counterclaimants, also did not file any application to bring on record the respondent number 1 in the 4 applications. And in view of the non-disclosure by either the petitioners herein as well as the respondent number 2, who were the plaintiff and the defendants in the suit, the respondent number 1 have been cheated, deprived. He therefore submitted that this is a case, pure and simple case, where fraud have been committed upon the respondent number 1, as well as committed on the respondent, in view of the collusive act on the part of the plaintiff and the defendants, for which the application under Order 21, Rule 97, 90, 99, and 101 of the code, which were filed by the respondent number 1, was maintainable and have therefore rightly been held to be maintainable by the learned executing court. In that regard, the learned counsel, senior counsel, referred to 2 judgments. The first judgment pertains to a judgment passed by the single bench of the Punjab and Haryana High Court, rendered in the case of Bhagwan Bai versus Chiranji Lal and another, reported in 2009 SCC Online PNH 695. The second judgment is the judgment rendered by the division bench of the Bombay High Court in the case of Kuber Housing Investment and Finance Private Limited versus TCI Finance Limited and others, reported in 2013 SCC Online Bombay BOM 1644. The learned counsel submitted that in the case of the learned senior counsel further expanding his arguments, submitted, contended that the rule of lis pendens, as stipulated in Section 52 of the Transfer of Property Act 1882, shall not apply. In view of the very language used in the same section, taking into account that when a decree has been obtained collusively, the principle of lis pendens does not apply. He further submitted that the question as to whether there was collusiveness, whether the decree obtained by the plaintiff along with the defendant, that is the petitioners and the respondent number 2, was collusive or not, are questions of fact which can be adjudicated only before the execution proceedings, before the executing court in the said proceedings. The learned counsel, senior counsel, further submitted that taking into account the judgment of the division bench of the Bombay High Court, the proceedings so filed by the petitioners, by the respondent number 1, could not have been disposed of summarily, more so when there are allegations of collusiveness are apparent on the face of the said application. I've given the due consideration to the said submissions so made by the learned counsels appearing on behalf of the parties. From the materials on record, as has been stated in the previous segments of the instant judgment, it is clear that the petitioners, the respondent number 1 in the 4 revision applications, have purchased the property, the flats in question, during the pendency of the suit. This court had put a specific query upon the learned counsel appearing on behalf of the learned senior counsel appearing on behalf of the respondent number 1 as to what is the collusion between the plaintiff and the defendant, which have been alleged, which is being agitated by the respondent number 1 in the application, taking into account that the state application does not, on the face of it, disclose that there was any collusion. This court have also drawn the attention of the learned senior counsel to the observations made by the learned trial court in paragraph numbers while deciding issue number 4, 5, and 6, as well as also the observations made in paragraph number 34 by the by this court in disposing of the regular second appeal, wherein the submissions were due made on behalf of the respondent number 2 herein, that is the plaintiff, as regards the sale being made, sale of the flats made to 20 flat owners. And the said contentions being totally negated by the trial court as well as this court. The Leland Senior Counsel submitted that the said aspect can only be discerned during the proceedings this has to be only discerned and proved during the proceedings before the executing court. First, this court is not satisfied with the said answer, taking into account that the said proof has to be based upon pleadings which, in the opinion of this court, are not sufficient for the purpose of bringing into account the fact of collusiveness. Okay, I won't spoil your lunch now. I'll have it second half. I'll again. Collusive. The fact that the decree was obtained collusively. Be it as it may, this court finds it very pertinent now to take note of the provisions of Order 21, Rule 102. The said rule being relevant is reproduced hereinunder. Rule 112(2) clarifies that Rule 98 and 100 of Order 21 of the Code do not apply to transferee pendant light. A bare reading of the said rule makes it clear that it is based on justice, equity, and good conscience. A transferee from a judgment debtor is presumed to be aware of the proceedings before a court of law. He should be careful before he purchases a property which is the subject matter of litigation. This Rule 102 recognizes the doctrine of lis pendens recognized by Section 52 of the Transfer of Property Act 1882. The legislative intent behind the incorporation of the said rule is to take into account the ground reality and to refuse to extend helping hand to the purchasers of the property in respect of which litigation is pending. Inasmuch as, if unfair, inequitable, or undeserved protection is afforded to a transferee pendant light, a decree holder will never be able to realize the fruits of the decree. Every time the decree holder seeks a direction from a court to execute the decree, the judgment debtor or his transferee will transfer the property and the new transferee will offer resistance or cause obstruction. It is on the basis of the said intent and to avoid such a situation, the rule have been enacted. This court at this time, at this stage, finds it relevant to take note of the judgment of the Supreme Court in the case of Tushar Sinha Supra, wherein the Supreme Court in unequivocal terms observed that a purchaser of a suit property during the pendency of a litigation has no right to resist or obstruct execution of a decree passed by a competent court. It was observed and declared that if resistance is caused or obstruction is offered by a transferee pendent plight of a judgment debtor, he cannot seek benefit of Rule 98 or 100 of Order 21. This court finds it relevant to reproduce paragraphs 23, 24, 25, and 26 of the said judgment, as the same has a relevant bearing to the adjudication of the instant proceedings. The said paragraphs are reproduced as hereunder. In the instant case, it would be seen that the petitioner, the respondent number one, who were the applicants in the various applications filed in the execution proceedings, had purchased the properties, has purchased the flats pursuant to filing of the suit as well as the counterclaim. Under such circumstances, they have purchased. Under such circumstances, as they purchased the flats in question, when the litigation was pending and the matter was sub judice, the respondent number 1 in the instant proceedings cannot invoke the provisions of Order 21, Rule 98 and 100 in view of the specific bar contained in section Rule 102. The learned executing court, by the impugned order, totally misdirected itself in not taking into account the provisions of Rule 102 of Order 21 in the proper perspective. And more particularly, in view of the law laid down by the Supreme Court in the case of Usha Rani Supra, as well as Silver Line Forum P Limited versus Rajiv Trust, reported in 1998 3 SEC 723. Consequently, this court is of the opinion that the application so filed by the respondent number 1, being application number so and so, was not maintainable on the face of it, and accordingly ought to have been dismissed as not meant, ought to have been rejected at the outset. Which the learned executing court failed to do so. Accordingly, this court therefore rejects the application filed by the respondent number 1, being application number so and so, and directs the executing court to proceed with the execution in accordance with the decree so passed. Accordingly, this court interferes with the order dated so and so, passed in so and so, order dated so and so, passed in so and so, miss case number so and so. With the above observations and directions, the instant petition stands allowed. I think there will be 4 judgments.
Yeah.
It will be making it clear.
Lordship, time frame maybe made your lordship directing. that
Absolutely no.
we didn't
No time frame business. You know what to do.
execution, your lordship.
Mr. Ali, why? Nowadays, this is for the execution court to do whatever it is. Why should I frame a time frame now?
3 months or 2
Hmm?
months, like 3 months or 2 months like this, because it's very difficult to execute it nowadays.
It is very difficult to execute. You know what to do. Taita ko. Etata ko.
Quickly operate.
Ay, tate ata line leke ko. Itare court ata line ata. मुझे कोलू 102 is accordingly. The above therefore answers the submissions made by Mr. D. Das, the learned senior counsel, to the effect the above analysis.
Quickly operate.
Was there any stay?
Yes. Undertaking was there not to go ahead with the execution. So that undertaking will not be there after
No,
this.
it's now. Eh,
He also has.
The before parting with the record, this court makes it clear that the order dated 36/2023 passed by this court no longer survives, and the learned executing court shall proceed with the execution in accordance with law. ISNI? Yes, what is this? What happened in that case that day?
I've taken out a printer, I've taken a printer of the.
Hmm.
And the next day I think on.
Other side appeared.
No, madam, they have not appeared.
Why the service is not complete? Why the service is not complete?
My staffs were absent, madam. Staffs all were absent.
Then you have not taken steps and now you are asking for injunction.
I'm sure we have taken. That report will show, madam, that we have taken step.
Huh?
But that order will show, madam.
What?
But the case speaks for SR and court, madam.
No, have you, SR is okay. Have you served it?
The service report. Case speaks for service report, madam. At this matter, we have taken step, madam.
Mr. Counsel, have you served the notice?
Yes.
Then why is it for SR? It can't be for SR. If you have served the notice, the court will proceed ex parte.
We have taken step, madam.
You have not served it.
They have not received it.
They have not received it. If they have not received it, the consequences will be, you will obviously show that they have not received it. There will be an order to that effect. Then?
But the next date is fixed on 6/6, madam.
Then?
On the last occasion, my lordship was making a query, madam. Regarding the task and force. Lordship may kindly for a moment come to page 90. There is an order of the sub-divisional officer, madam. That the hand was pulled by one of the Patada, madam. So the dual court, madam, the subdivision office has set aside the scale dip and kindly speak, madam, page 90.
No. First of all, you have to satisfy this court why you have not served it.
Yep. Page 90, madam. Type copy. Order is at page 92, madam.
Page?
Page 90.
90. Yes.
Is a type copy, madam.
Yes. What is it? What are you asking for?
Lordship on the last occasion made a query that the original Patada were posed and we are tasked. At least order will show that we are also the co-Patada.
So the question of selling does not arise. As regards construction, have they raised construction?
But this order, it says that without partition, the land cannot be sold.
Have they taken any permission for construction?
No, madam.
Then why you are worried?
But what I am thinking, madam, that this kill the tendency of the national petition. This may be They may be status quo. I'm asking about only status quo, madam.
No, status quo is an injunction.
I'll leave it
Yeah.
to-
No, absolutely. Because you see, the thing is that service has to be meted out.
We have taken this step, madam.
Mm. You had a co-patada. So,
And madam, we have filed a petition before the circle office, madam. My lordship may
you
kindly
see, the defendants with an intention to deprive the plaintiff have illegally started to construct the Assam type house. Have they constructed?
they are constructing, madam. They have made the boundary
So,
wall.
show me the photographs. Show me the photographs.
On tomorrow, madam.
What tomorrow? The defendants have also constructed a boundary wall and an iron gate.
Yes, madam.
Then, show me what is your right. They can't sell it. That is okay.
That is sure.
Then,
My lordship may kindly see page number 109, my lord. This is the application, my lord, for partition. After receipt of this application, my lord, they have started construction. Now, page 109, my lord.
what is your relief sought for in the plain?
109.
Declaration that the plaintiff being the son and daughter-in-law are co-owners of Schedule A property along with the defendants. Declaration that the plaintiff being son and daughter-in-laws are each of them are entitled to a preliminary decree for partition. Then,
Lordship may kindly come to page 109.
they are related.
Yes, madam.
Why you have not been able to serve them?
Kindly see 109, madam. We filed the petition before the circle office. Filed for 109.
For what? Not to sell.
No, madam. This is the for partition, madam. 109.
Yes. Then,
This is the application, madam. The acknowledgement. We filed an application for partition of the property.
Hmm.
After this, madam, notices were issued, madam. Then, the next page, madam.
where is the impugn order?
Issue order is at, madam, page 119, madam. Except it.
There's nothing wrong with this order passed by the trial court.
But the trial court had issued a notice without the trial court had issued notice, madam, without containing any.
Absolutely.
Yes, madam.
Then, here also this court is going to issue notice only, nothing more than that. But issuing a notice out here doesn't make any sense.
That's why I'm telling, madam, saying before lordship.
So the only thing is to dismiss. Yes, no, the reason why, if you were in urgency, why didn't you get it served? It couldn't have been fixed for SR. If it is fixed for SR means you have not taken steps. You see, Mr. Counsel, I was also a lawyer in the trial court, so I know how to delay the service. You may very well take the steps and will not instruct the person concerned to go there.
No suspect.
And this is why this is happening.
My friend personally went to that court, madam. I mean, madam. He personally went to the court, madam.
To?
My friend, madam.
To whom?
To take step, madam. To the court, madam.
Understood. The steps is being taken. Everybody knows the steps are being taken, but the steps are you need a push. That push is not there.
Push was there, my lord, because of the Bihu, my lord, oncoming, upcoming, they are access, my lord. That's the reason.
Bihu was before. The order was passed on 7/3/2024.
It was there, my lord.
Eid was only on 18th.
That's the matter.
Then order is passed on 7/3.
I'm not going to take it. But I submitted my prayer, my lord. I got it. So the thing is that after receipt of the notice for partition, they started the construction. That is the main issue. The largest trial court.
No, Mr. Counsel, you have to appreciate one thing. For this court, the court had exercised the jurisdiction not to grant you an injunction of status quo on the ground that you have failed to do so. Neither you have produced any document that they have raised any construction. Where?
Prayer, my lord.
What?
In the prayer, my lord. In your petition, my lord.
Where is that document to show that they are raising any constructions?
Kindly document, kindly please.
Then why didn't you place it before the trial court? You do one thing. You withdraw this. I give you the liberty to move an application along with certain documents asking for urgent relief. And if that be said, the court shall consider on the basis of the materials. I am not going to touch. This is an appeal under order 43 rule 1R of the Code of Civil Procedure 1908, challenging the order dated 7/3/2024, passed by the learned 7/3/2024 in Mizze case number 83/2024, arising out of title suit number 52/2024 by the Court of the Civil Judge Amingaon, whereby the learned court below had issued notice and did not grant the ad interim ex parte injunction order against the defendants. Footstop. This court had perused the said order dated 7/3/2024. And the perusal and upon perusal thereof, this court is not inclined to interfere with the same, taking into account that there is no material placed which would show that there was any construction raised by the defendants. Footstop. The learned counsel appearing on behalf of the appellant submits that there are documents which would show that the defendants are raising construction by constructing an Assam type house over the suit land. However, the said documents were not placed before the learned trial court. Under such circumstances, this court is not inclined to admit the instant appeal, for which the appeal stands dismissed. This court, however, is of the opinion that if the appellants herein have documents to show that any construction is being carried out, the appellants would be at liberty to file an appropriate application before the learned trial court seeking urgent relief. And the learned trial court shall be at liberty to pass appropriate order taking into account such documents without being influenced by the fact that the instant appeal has been dismissed. With above, the instant appeal stands dismissed. Okay. Disposed.
Assam type house along with boundary wall.
Boundary wall has been constructed. Then
Newly, man.
no, you have already mentioned in paragraph number 18 The boundary wall has been constructed and they are there.
Completely constructed, madam.
Then
Lordship may add that what, madam?
what?
Boundary wall and under house.
No, I said any construct
Anyhow, okay.
disposed to it.
I have filed this appeal, my lord, against the order passed by the Learned Civil Judge. That is at page 89. This is an order passed in the injunction application, my lord, wherein the injunction was made absolute. 9/8/23, my lord. I am agreed by this order, my lord, on the ground that in our objection, my lord, we have categorically taken the stand, my lord, at page 81. That's the T patta left.
Hmm?
The T patta left.
Hmm.
So there couldn't have been a case for sale of the land. At best, it could have been a case of lease. Though they have offered us some money, we have accepted the money, we were willing to return back the money. In our written statement, we have taken the. So the injunction could not have been granted, my lord, because it's the T patta land, my lord. And moreover, my lord, there is an
What is the suit for?
suit for, my lord, specific performance, and also there is an alternate prayer, my lord. Prayer is at page 38, my lord.
Suit for specific performance of?
For execution of the sale deed, my lord.
Hmm.
Liable for execution of sale deed at page 38, my lord.
Hmm.
The
Then?
registration of sale deed. Then
Hmm.
alternate, they have prayed for an alternate prayer, my lord.
Hmm.
That in case the sale deed is not executed, then refund the money of 67,75,000.
Hmm. Then?
And for permanent injunction for not to alienate the property.
Then?
That's it, my lord.
What do you want?
So I'm agreed by this order because if there's an alternate prayer made, my lord, so it is not a case that the injunction ought to have been granted. And moreover, this is a T patta land. The learned court below ought to have appreciated the objection which they raised in our objection. Then that since the T patta land,
So that will be decided in the trial.
the permission of the government is required.
What is the problem? The court has only passed a status quo order.
So, my lord, may kindly peruse the page 100, my lord. There's the WP message
For what?
of 2006, my lord.
Regarding?
Regarding sale of the T patta land, that permission of the.
That I know. Mr. Sikedas.
Yes, my lord.
How does it matter? You can sell it. Don't sell it.
That is my.
The only direction is to maintain a status quo.
The direction is a page, my lord.
Yes. In view of the above directions, we are instead the status quo order here is extended till the. What is the status quo order?
Page status quo order, my lord, is page.
Earlier order is
Page
where?
63.
Huh?
Page 63.
53.
63.
Nature, character, status, ownership, and possession. So you are in possession, you remain in possession. Ownership, you are the owner, you remain in owner. Status, you can't convert it into a thief from other things. Character is also the same. Nature is the same. So how does it matter? You should be happy.
My lord, there's a page.
Unless you have some idea of selling it to somebody else.
Because I have said that we are going to refund the money. In our written statement, we have taken specific stand. We have taken, my lord, that we are going to refund the money. It cannot be sold, my lord.
So?
That we have taken in our written statement and also in our objection.
So?
That, and my lord may kindly peruse at page 98. My
So you have the provision of order 24. Take the help of that provision.
as regards the maintainability of the suit, the learned judge had held, my lord, at page 98. My lord may kindly peruse.
Why?
It says, my lord, insofar as the contention of the opposite parties regarding the maintainability of suit, as well as the inability of obtaining a specific performance is concerned, the same is a matter which needs to be discussed during the conclusion of the suit, after evaluation of the evidence and materials adduced by both the parties during evidence hearing.
Rightly?
My stand, my lord, is that if my lord may kindly peruse this objection which we have faced, my lord kindly may peruse the objection.
No, how are you aggrieved?
Because that
Unless you want to sell it to somebody else. You want to sell it to somebody else.
No, there's no question.
Yeah. Status quo. Very well. They, at the end of the trial, they would not be entitled to. You want to pay back the money, then exercise the powers under Order 24. Deposit in the court, let them take it or not. If they don't take it, that is their lookout.
My lord, may kindly peruse just one page 83, my lord, may kindly peruse, my lord,
For what?
which we have taken as T, my lord.
Hmm.
That since the petitioner is advised to take a perpetual lease of the suit and ST periodic patta as per government policy is not transferable. That is our standing.
Who says the government policy that the tea land is not transferable?
Because the government has, the permission of the government has to be taken.
So,
Which-
normal land also, they don't you require under permission under 21A. Then all lands cannot be sold then. There cannot be a specific performance. No case. So, dismiss. Withdraw. Either of it.
It may not affect the merit of the case, my lord.
Absolutely it won't. That only I will observe. What do you say, Mr. Datta?
Lord,
Yes, you
Lordship has
have been engaged, so I'm asking you.
Lordship has
Otherwise,
already
what will
stated
the client say later on?
they have some other idea to sell it to somebody else.
Huh?
They have some other idea, my lord, as your lordship is indicated, and that's the right thing.
No, order is right. There is no touching with that order.
Exactly. And your lordship will only exercise the power if the order is passed in arbitrary manner.
No,
That is
not
not
only
there.
that. Question of the order seems to be perfectly okay. The submission is made that there is an alternative prayer being made of amount. Very well, the Supreme Court has categorically mentioned that you can always have alternative prayer in a suit for
In the event, my lord, the decree cannot be passed against me. In that case only.
You have seen the order, section 21(5) makes it clear you have to have. If you don't have it, later on you
Yes.
cannot ask for.
Exactly.
So, the law is there. Okay, Leho. Withdraw. Okay. This is an appeal under order. This is the instant appeal has been filed under Order 43, Rule 1R, challenging the order dated 9/8/2023, passed in Mize case number 42/2021, in title suit number 25/2021, whereby the court of the learned court of the civil judge, senior division Dibrugarh, had directed the parties to maintain status quo. In respect to the nature, character, status, ownership, and possession of the suit property. The learned counsel appearing on behalf of the appellant submits that taking into account the order which have been passed, he would not further agitate the instant appeal. However, he submits that the observations so made in the impugned order, as well as in the order dated 1/11/2021 in Mize case number 42/2021 should not affect the final outcome of the suit. Taking into account the above, the instant appeal stands closed on withdrawal. This court makes it clear that the withdrawal of the instant appeal and the observations so made by the learned trial court shall be restricted to the adjudication of an appeal of an injunction proceedings and nothing further. The said observations made in the impugned order as well as in the order dated 1/11/2021 in Mize case number 42/2021 shall not influence the learned trial court while adjudicating the suit. The above the instant appeal stands closed.
Okay.
Stands closed.
Attempt 12.
Yes.
Second appeal, my lord, arising out of the matter judgment passed by the learned senior division, Nagaon, my lord. Page 30 is the my lord, trial court judgment. It was passed by the Munchik number 2 at page 30. My lord, the plaintiff filed a suit against the defendant. The defendant, after filing his written statement, has expired. The main contention is this, my lord, this tail deed is in fact is a forged one because he did not put his thumb impression in the tail deed, but he will not expire before giving any evidence. As he was, my lord,
Mr. Goswami, what are the substantial questions of law you
yes,
have formulated?
regarding, my lord,
Under no circumstances this can be nearby said to be a substantial question of law.
is a fact, my lord, but this is the problem, my lord. Attesting witness, regarding attesting witness, he was not examined.
Is it required? Let us also get gainfully acknowledge or is it required?
What happened?
This is not a will.
No, not a will.
Then?
The sale deed, and my lord, he was killed at the time of my lord registration of this sale deed. This is, in fact, reflected in the judgment by the Munchik, my lord.
So,
in the cross-examination, plaintiff himself has admitted that he was suffering from paralysis, so he could not move, my lord. Then how he can go to register the sale deed? And this is ancestral property. The 1 acre of land, which is owns here, and he. Why he will
both the
see-
judgments are against you.
Yes, good.
You are a plaintiff.
No, I am the defendant. my lord.
You, what is the suit for?
Suit for my lord, title and possession.
Title and possession.
Yes.
Then,
Then my lord, decree was passed in their favor. Then this present appellant preferred this.
where is the plaint?
Plaint at page below 45. Start 43, Annexure 1.
Sale deed was purchased.
Yes, the registered sale deed at page para 2. It is the registered sale deed number 1278 of 1999 to meet its financial constraints and delivered possession thereof in favor of the plaintiff. This was the case, and at page 45, it is in regard to the prayer, my lord, the plaintiff title be declared in respect of the land in schedule 4 below, and he be awarded the first possession. And the schedule land is, my lord, 1 bigha out of total 11 bigha 14 letter. The ancestral property, my lord, he got his 1 bigha of land, and his brother also got 1 bigha of land. They are in possession.
Who is the defendant number 1?
The defendant number 1, he already died, my lord, in 2006. After filing his written statement, he expired. He said that I have not given any thumb impression on any sale deed. But before giving any evidence, he expired. Okay. So, my lord,
Then,
my lord, the title appeal was, my lord, again dismissed by the trial appellate court. Is the problem.
so the defendant number 1 transferred this property by way of a deed of sale in 1999
99.
to the plaintiff.
Plaintiff.
Now, thereupon, the plaintiff
Filed this title
suit
for title and possession.
for title and possession.
And the
trial court below, my lord, right title interest was granted to him, the plaintiff. This is, my lord, at page 30, lordship may kindly peruse. No. Mainly regarding the S2 number, my lord, 3, that has been discussed in detail, and it was regarding the sale deed. Whether the sale deed number so and so is a genuine sale deed and executed by Samed Ali in favor of the plaintiff by receiving seal consideration and delivered possession of the suit land to the plaintiff. Now, regarding Miller this, the plaintiff has, the defendant has filed his written statement, then he expired in 2006, Miller. On 5/12/2006, he expired. Then Miller, other legal years, legal representatives were Miller, they became the defendant Miller. They were implicated as defendant Miller. Then they filed also.
No. The principal defendants filed a written statement on 16/5/2006.
Yes.
The sale was made by one Mr. Samed Ali.
Samed Ali.
Now, Samed Ali died earlier.
Samed Ali in
2006.
2006.
And how is it possible?
Sale deed in 1991.
No. Tell me one thing. This is a translated copy.
Yes.
Now, kindly come to page 54. Samed Ali was the owner and possessor of the suit land till 5/12/2006. If that be so, how is your file on 16/5/2006?
No, this is by the other Miller.
No. The verification is by Samed Ali,
Samed Ali.
16/3/2006. There's some mistake somewhere.
Some mistakes are there, sir.
Then?
But the Assamese one, at page 50.
Let's see the trial court judgment.
Yes, at page below
Huh?
30, 24, starts from 24. Page 29. Page 29 is Milord the.
Razor raised the sale lead.
Yes, Razor.
You have not challenged that.
Milord, he expired.
So what?
He filed a written statement there. No, he has not Milord challenged.
Then
Yes, fact.
we have not challenged what remains.
The fact.
The sons, Samed Ali has sons,
Yes.
so they have to challenge it. If they have not challenged the sale lead, then what remains?
My lord, it was in our favor in 1991.
Understood.
Samed Ali died in 2006.
Understood.
And
Everything.
Samed Ali filed written statement also. After filing written statement, died. and attesting witnesses and scribe also examined in this case. They have said that Samed Ali executed this deed.
Where is that?
It was proved at page 29, trial court judgment. The sale deed was proved. The learned counsel for the plaintiff submitted he has purchased the woodland from the owner. This is
Yeah. See, page 29, that is
Yes.
there. Then what remain?
But my lord, at page 30, it is here. In the my lord, third paragraph. The learned counsel for the defendant, on the other hand, has submitted in his written statement argument that the deceased Samed Ali had never executed any sale deed, nor did he hand over possession to the suit anyone. Referring to the above evidence, PW learned counsel for defendant submitted that PW1, the plaintiff, Mohammed Haber Ali, has categorically stated in his cross-examination that the seller Samed Ali was seriously ill at the time of executing sale deed. In fact, he was partially paralyzed, and he was difficult for him to move properly. Then, in such situation, it is hard to believe that this is Samed Ali had accompanied the plaintiff to the register office for it. These things are dear, my lord. Now, without going to the my lord, the sale deed, my lord. And there is contradiction of the plaintiff witness itself, my lord. The PWT Hafizuddin, who had submitted in his cross-examination that at the time of selling the land, the deceased Samed Ali was not suffering from any ailment, and he did not alienate the truth land for sake of money. These things are, my lord, some contradictions are there.
These are findings of fact. And hello, let me dismiss it. How you want to look into something more, or should I dismiss it?
If your lordship permit me for some more time, then
Hello. ठीक है, I'd give you time till Thursday.
no, my lord. Next, first week of May, my lord.
Why? You like the date?
Yes.
Huh?
Not like
Why? And there's something, must be good reason for that. But in the May, why?
the first week of May, anything.
First-
First week of May.
Why?
No, my lord, I have some difficulty.
No, difficulties, I can relieve you the difficulties by dismissing it right now. If you have difficulty. This is going to be the fate. Only thing is you want to not do it today for whatever good reasons you may have.
Up to your lord.
Let's have it on Thursday. Finish it off. No, this is not a second appeal to be admitted. The questions, the two questions which you have done. One is without attesting that it is on facts, it is there. And the second is about the thumb impressions. Have you asked the sending of to the FSL?
Not a
No.
will, my lord.
Huh?
Not a will. Not a matter of will. They only sale deal. I know that, lord. But
No, not only that. The second substantial question of law which you have proposed is as regards sending it to the FSL. Whose duty it was? You should have sent it.
it was rejected. Earlier it was rejected.
So if it was rejected, then did you move again under Order 41, Rule 27? You have
It was
not.
there.
Huh?
As because the my lord, the defendant died, therefore the London trial court, my lord, they refused to send it to the FSL.
Hmm.
Their problem.
Hello. Finish it off. Unnecessarily, why should it remain? The instant appeal is filed under Section 100 of the Code of Civil Procedure, for short the code. challenging the judgment and decree dated 28/5/2019, entitled Appeal number 15/2015, whereby the appeal was dismissed, thereby confirming to the judgment and decree passed by the learned trial court dated 21/4/2015, entitled suit number 122/2005. For the yeah. From a perusal of the memo of appeal, it transpires that two substantial questions of law have been proposed. The first substantial question of law so proposed is whether the proof of the sale deed is valid without examining any attesting witness in the court below by the plaintiff when the execution of the sale deed is denied by the defendant of the suit. In the opinion of this court, the said substantial question of law does not arise at all, taking into account that PW2 was the attesting witness and PW3 is the deed writer who were duly examined. Under such circumstances, the said substantial question of law so proposed is totally misconceived. Next. The second substantial question of law so proposed is as to whether the thumb impression put in the sale deed and the thumb impression put in the wakalatnama by the executor of the sale deed is capable of being sent to the FSL when the executor is dead. The said, in the opinion of this court, cannot be a substantial question of law, inasmuch as the same does not have its foundation in the pleadings filed by the defendant, as well as also from the evidence, from the materials on the basis of which the judgment and decree was passed by both the courts below. Under such circumstances, the said substantial question of law which have been proposed does not arise. In addition to that, this court also finds it very pertinent to observe that the deed of sale which have been marked as Exhibit 2 is a deed of sale of the year 1991, whereby the plaintiff claimed that the suit land was transferred by the defendant to the plaintiff. By the defendant, Samed Ali, to the plaintiff. The said deed of sale have not been challenged. Said deed of sale, the registered deed of sale have not been challenged by the appellant, by the defendants or by the defendant, as well as the appellants herein. Under such circumstances, this court finds no ground for exercising the powers under section 104 of the code, inasmuch as there arises no substantial question of law which can at all be formulated, not to speak of being, which can be formulated in the instant proceedings. Accordingly, the instant appeal therefore stands dismissed. I am closed.
Okay.
I relieve you.
Here, in this case, I have only one ground to proceed. Basically, I'm going to say. The plane itself is not cleared, and the evidence, whatever he has given, it is not clear that what is the source of that property. Just he started that earlier 21, patta number 21 is there, and he has separated and new patta and got the,
You are the plaintiff?
I'm defending.
Suit for compensation?
Declaring right title is recovery of both.
Counsel, I think you need to improve your translation. Not done properly. The suit for right title and interest. You have mentioned is suit for compensation. And for decree for permanent injunction and exclusive possession of the land by declaration of title.
Lord, get this up time. Correct.
Patta has already been given
Patta has already been.
by the revenue authority. Then have you challenged the patta?
That is the question, your Lord.
You have not challenged the patta, then how do you do that? Your entire suit is baseless.
I'm dependent, your Lord.
Understood.
Yes.
You see, the patta was given to the plaintiff.
Patta was given to the plaintiff
145.
Out of the joint property.
Whatever may be. Who
is
gave it? The deputy commissioner gave it.
Yes.
You have challenged the patta.
He has challenged, but that was dismissed. But
Before
that is
the-
not on record.
Then
It is not on record.
that is why your entire substantial questions of law is baseless. Already the patta has been culled out.
But patta has been cut out from the joint property.
Maybe, whatever may be, 145 was culled out.
And it is not the case that whatever the suit property, that is the suit land, is fall under his share. How he
Mr.
got
Counsel,
patta,
kindly appreciate one thing. Out of a joint family property, he applied for patta
he applied for
before
patta, but
before the revenue authority.
no notice has been issued.
Whatever may be, right, wrongly. Let us assume that wrongly a patta has been given by bifurcating out and a separate patta has been issued to him.
Yes.
So under such circumstances, he is asking for declaration of his title as well as for possession,
Yes.
exclusive possession of that property. On the basis of the patta which has been culled out.
Yes.
Either you have to challenge that patta, which you have done or not done, that is a different aspect of the matter. And secondly, it was you who have to file a suit. He already has the patta.
Here, only the one ground is there here. Okay.
There is no ground at all. What ground?
Because it's a joint property.
Again, I would have understood if the patta was not issued by the government. The government have issued a patta to him. You have not challenged that patta. It is he who is asking for. You did not file a counterclaim. How do you maintain your suit or the appeal? And you have how much? 16 substantial questions of. Well,
Only, only on the basis of one fact. Because it is.
and the fact is very clear.
Just you also get me some time. Because it is an admitted fact that in his cross-examination, he has admitted that the land, original patta number 21 is in between their brothers.
Absolutely right. But whose suit it should have been? Your suit. That this could not have been brought here. Where the government had to be made a party. The patta has not been put to challenge, then where do you have? Your legs are not there. The appropriate word would be cloud heaven.
Here, his case is that he has filed an appeal, but that has been dismissed before the revenue authority. But he didn't challenge here. There is
He
no
filed an
conflict.
appeal before the revenue board. If the appeal has been dismissed,
Yes,
you should have filed a writ.
yes.
But he has not done
He has
anything.
not done it.
So if that is not there, there is no challenge to the issuance of the patta. So he's right. Anyway, you one time, take time. The learned counsel appearing on behalf of the appellant submits that the translation which have been provided, translated copies of the plaintiff as well as the written statements so provided is not correct. He submits that he may be given 4 weeks time for the purpose of providing better translate copies of the plaintiff and the written statement. To list the matter after 4 weeks.
2 weeks. After 2 weeks.
On the inevitable so soon. I'm here till 4 weeks, don't worry. So therefore I'm putting it up. After 4 weeks, I may not be.
Apply.
Para 43. Stay with us.
Yes, Mr. Oloskar. Sorry, what are you challenging?
In this case, the petitioner was supposed to file a PTP in respect of service of notice upon response of 10, 11, 14. So, service has been effected by the team, but the affidavit was not filed.
Yes.
So,
you have been regularly irregular. PW1 and 2 have been expunged.
yes.
Then you
The-
filed
this is
this
the main
petition.
petition.
Huh?
Yes, this is the main petition.
PW1 and 2 was expunged because of the fact that at the time of cross-examination, they did not appear.
Yes.
Now you filed another application that you want to give any further evidence.
Yes.
When?
For recall of the order expanded label. Taking recall of the order expanded.
Where?
The
Show me your petition.
page 130. This is vernacular 128.
Page?
Page 128. The last part.
Then
So by the impugned order, this
when was it expunged?
the
PW
order-
2 and 3, 1 and 2 was expunged on 18/2/2020.
Yes, this is 18 to 2020. It is at page 120.
PW1 died.
No, my lord. So PW1, that is the problem, my lord. I was trying to make this submission that the petitioner hearing, who is the PW1, was admitted in the hospital in critical condition, and thereafter I couldn't contact him. But yesterday I called the local lawyer who was conducting the, and he also said he was trying to contact him, and he assured that within 1 week or 2 weeks, physically contact him.
So that was expunged on 7/3/2009, expunged on 11/2/2019.
PW1
Was expunged on
11/2/2019.
11/2/2019.
Yes.
Then the second was
Second.
expunged on
18 to 2020.
okay. Then
Then this application was filed for recalling this order.
is this the application for recalling?
Yes, the language is a bit peculiar.
What?
The language is not.
We have to understand what is inside the mind of the council.
The translation for setting aside, it is setting aside the order dated 3/2/2021.
This application cannot be said to be expunging. And why did you file this application? When did you file this application?
It is
2021.
yes,
18 to
18 to 2021.
and expansion happened on 3/2/2021.
Yes, 21.
Then
So this application was rejected by the order at page 131.
Hmm.
Order dated 6/12/2021. And
Then?
the suit was fixed for DW evidence. So plaintiff evidence has been closed. The
you
evidence
want to
already
give
on record.
any other evidence, you can. I can give you an opportunity. One more, but no bringing PW1 and PW.
My humble submission is that in view of the explanation to order to rule 2 to order 70, expansion is not permitted.
What?
Order 17 rule. Mandate.
Tell me.
Rule 2 states where on any day to which the hearing of the suit is adjourned, the parties or any of them paid to appear, the court may proceed to dispose of the suit in one of the modes directed in that behalf by order 9 or make the other order as it is made. Explanatory, where the evidence or a substantial portion of the evidence of any party has already been recorded, and such party fails to appear on any day to which the hearing of the suit is adjourned, the court may, in its discretion, proceed with the case as if such party were present. So,
Mr. Counsel, read order 18 rule 4. 18 rule 4. You have the CPC or did you own? Huh?
no,
Mr. Counsel, you are appearing before this court
Right.
without a CPC. Can you say the evidence on affidavit to be evidence?
Yes.
To me. See the word used in the CPC. What is an evidence on affidavit? It does not say it to be evidence. It becomes evidence only at the time it is subjected to cross-examination. is there. Kindly see, order 18 rule 4. You see, the evidence on affidavit is always used as examination in chief. Order 18 rule 4.1. In every case, the examination in chief of a witness shall be on affidavit and copies thereof shall be supplied to the opposite party by the party who calls him for evidence. Then you see, documents, the evidence, what it becomes the evidence. Number 2, the evidence, cross-examination and re-examination of the witness in attendance whose evidence examination by affidavit has been furnished by to the court shall be taken together by the court of the commoner appointed by it. So under such circumstances, unless that person who filed the evidence on affidavit does not come and step into the witness box and affirms, say, then look here, this is my evidence, it does not become evidence. You wanted the court should on that day itself dismiss the suit. That is your submission. That is what it appears. If we apply order 17 rule 2.
The court can proceed with it.
No, the moment you that is no evidence. If on the date on hearing, if the person fails to give evidence, the court should proceed in terms with order 9.
I'm relying on a judgment by the Kolkata High Court.
Who?
Kolkata High Court.
Go to Calcutta for that.
But
there are many judgments.
Your Lordship is not bound by Kolkata High Court.
Not only bound. The question is there are many judgments. See the beautiful judgment of the full bench of the Andhra Pradesh High Court in 2005. How a document, how a person, when it becomes evidence, 2005, it's a full bench judgment.
I just tell my Lord, as far as the well-settled principle that the evidence of a witness will not be expunged, but its evidentiary value considered at the time of hearing, despite...
This is no evidence at all.
Despite
Mr. Loster, this cannot be evidence because it is hit by Section 3 of the Evidence Act. Evidence Act, Section 3 hits it unless it is permitted as per the CPC. The CPC does not say this to be evidence. It says only to be examination in chief. It becomes evidence the moment you are put into cross-examination or you come to the dock and say, then look here, this is my evidence on affidavit. Then he is to be cross-examined. This is how it happened.
But here, despite cross-examination of such witness having not been completed. Even cross-examination is not done.
It cannot be evidence at all. Rightly said.
Here it is said that it cannot be expunged.
Better off, let me take note of that and hold it that that is not the law. You go to Supreme Court for that. Give. Better off. I'm not going to hold that.
So in that case, may be given some time.
For what?
I'll look into this.
I'm not extending the stay.
For 1 week.
Not after 3:30. Stay does not be there after 3:30.
Kindly, I'll satisfy your Lord.
It has to be expunged unless you are there to there's a full bench judgment of the.
There is also, my Lord, it's commissioner not cooperated.
Huh?
Commissioner who was appointed for recording evidence did not cooperate with the council.
Mr. Counsel, why should I go into all those things?
So
you accepted those orders as far back as in 2019, 18. And thereupon, you were given the further opportunity of giving further evidence. You did not do so. And look at your application. Your application says something else. That he should have filed an application asking for further time for giving evidence, but he did not. This is your application. Then why should I deal with those? Oh.
If evidence are not taken into record, my lord, the suit will fail. If evidence is not taken on record, the suit will fail.
So
some
go to
court
the
will-
legislature and ask them to say
some cost will be
say
imposed.
that
There is
whatever
a reasonable amount of
No.
maybe.
this court cannot look into under 227. I may only touch this order of 6/12/2021 saying that a further opportunity, but not PW1 and PW2. Some other you want. Because you have duly accepted that.
PW1 appeared several times before the commissioner.
But you didn't challenge that. Did you challenge that at the PW1 being expunged? No. You never challenged that. PW1 then came to PW2. Then also you did not challenge that. Nothing doing.
Page 90. Clear, page 92, my lord. Order sheet clearly says that advocate commissioner is not cooperating in the process of recording.
Mr. Counsel, you have not raised that issue before the trial court. You never raised that issue. Can this court also sit over it? Yes, yes. Mr. Counsel, what do you have to say?
Page number 98, 91, my lord. Can you see order dated 5/11/2016, my lord.
Huh?
Order dated 5/11/2016.
Page 90?
Page 91. Plaintiff side is directed to adduce all further PWs, if any, within next date, and no further scope will be given.
In 2016?
Yes, in 2016, my lord.
But then
And my lord, and next page, my lord,
some defendants were substituted after. Some defendants were substituted after. So the proceeding was the recording of evidence was stopped for substitution.
for further cross, my lord, page number 92, my lord. The cost was imposed, my lord. Thereafter, my lord, several chances were given, my lord. Last chance was given, but further cross was not completed. Please, regularly irregular. The suit is of
What is this page 100? Part of it has been cross-examined, PW1.
Yes, partly correct, but not complete.
This was done in 2016.
2016, yes.
Then?
But not completed process.
Then, my lord, the defendant.
Then in 2018 also.
Substituted. Yes. Cross-examination. PW1 cross-examination, then the PW2. 2018.
820, my lord, the last chance was given. Thereafter, my lord, 21. Several last chances were given. But PW1 and
PW1 was processed.
And Mr. Counsel, you have not challenged that order also. 11/2/2019. How do I help you? I will consider, I'll do one thing, Mr. Olaf Scott.
Yes, ma'am.
I will allow this petition, make every correction, but a mistake I will take it on the council. And the council will be imposed the cost of 25,000. Count to deposit, not on him, not on that person, because it is the mistake of the council this has happened.
Take it back.
What?
I'll have to take it back from that.
For what?
For
Why?
the lordship is proposing to impose the cost on the council.
Upon you. Not upon the council, you. You are the person who made the mistake. That is the only way out.
Which is true.
Why do you need council instructions when I'm imposing the cost on you? You want to take instructions from yourself.
I beg your pardon, my lord.
You want to take the instructions from yourself.
No,
I'm not concerned with the client. I'm concerned with you. You made the mistake. You knew it to challenge this order of 11/2/2019. Why didn't you challenge it?
Your lordship perhaps means the council was conducting this.
You. Who filed this petition?
This petition, me.
Then it is you. I'm imposing the cost of 25,000 upon you for not challenging the order dated 11/2/2019. You need to be careful. You can't come up out here and just throw the petition before the court. You know the scope of the jurisdiction under 227 is very limited. It's all because of councils like you this has happened. Is it the absolute fault of the councils this has happened?
There is a mistake, my lord. This is bona fide mistake.
It's a bona fide mistake on your part, and you are making a submission before the court to that effect that when part of it's done, it cannot be dispensed with.
I'm relying on a judgment.
No, if you did you know about the judgment at the time when you filed the petition? If you knew about this judgment when you filed the petition out here, then obviously you knew about, you should have challenged this order of 11/2/2019. Why haven't you done that? The application which was filed before the trial court was horrendous, incorrigible. And all the fault remains with the advocate. Either they don't know head or tail about the petition to be filed, or they are not least bothered. They may be having too many matters out there. They are least bothered about the of the clients.
This is up to your lord.
Okay, I impose the cost of 25,000 upon you. to be deposited in the rate by 26th of April. I allow this petition to complete to 25,000.
That's that. If it is a mistake, my lord, it's bona fide.
Mistakes happens, and if the mistakes happens, it needs to be rectified. The rectified is a loss to the other side. And a mistake is by you. Then you learn for next time onwards. Till 2035, I'm here. That whenever you come before this court, you will be more careful. Isn't it a glaring mistake, Mr. Oscar?
My lord, yes.
Then?
It's a mistake.
Then?
But it is inadvertent.
Huh?
It is an inadvertent.
Inadvertent? That is why I asked you. You had the decision of the Calcutta High Court.
Yes.
Then, how can it be inadvertent?
To be very frank, my lord, I after filing this, I have started.
Huh?
After filing the petition, I have made some research, and then I got hold of the Kolkata. So it's up to your lordship, but I think very frankly take down.
Hmm? Yeah, all mistakes have happened because of the lawyer.
The application before the trial, my lord, it's setting aside of order dated 3/2/2021, by which evidence have flowed.
Mr. Counselor, you have to understand, if this court tries to help you also, you can't help you. Because of the manner in which you have destroyed the case of your client. Not you, the lawyer who was there. And who is Yasin Ali?
The plaintiff.
Huh?
Plaintiff 1.
And who is plaintiff number 2, 3, and 4? And why he is only before this court, not the other two?
He is actually representing them in the.
How can he represent them? Then you have to have 3 persons out here. You see, the problem which arises is the petitioner number 2, the plaintiff number 2 is before this court. Plaintiff number 3 and 4 is not before this court who has suffered those orders. How do I challenge? How do I set aside those orders? Four, 5.
Petitioner number 2, petitioner number 1 expired. Now the plaintiff number 1 expired. Now
Understood. Plaintiff number 2 has filed.
yes.
What about the plaintiff number 3 to 8? They have already suffered those orders.
Yes.
And they have not challenged it.
On their behalf, the plaintiff number 2 is before this court.
Oh, is it possible?
My lord,
Then why do you have so many other plaintiffs? Only one plaintiff would have done.
PW1 is petition as well. Is evidence of PW1.
Who is PW1?
Plaintiff number two. Plaintiff number two.
Plaintiff PW1. And his evidence of it.
And he has not challenged that order. How do I help you? Tell me, Mr. Counsel. Think about it. I give you 4 weeks. I'm not extending the interim order. Think about it. How to do. Mr. O. Losko, the Learned Counsel, appearing on behalf of the petitioner. 6 for
1 week will do, my lord.
2 weeks. 2 weeks time in the matter. First, list the matter of the 2 weeks. This court is not inclined to extend the interim order. So, Losko, this is very sad. I didn't expect you to be in such state of affairs. Yes, who is appearing? Yes, Mr. Storm. What are you challenging?
Lordship, the petitioner is the defendant, your lordship. He filed an application under Order 711 for rejection of the plaint. That was
Under what ground?
under the ground earlier, the plaintiff filed a previous suit, and that is pending in the appellate court. Res judicata. Same subject matter. Res judicata.
Res judicata. Res subsidies. Is res subsidies a subject matter? Can a suit be barred under res subsidies? You may ask for stay of the trial. The question of that you may ask the stay for the trial of the suit. Nothing much further beyond that. What type of application is this?
Order 11,
Res judicata, has it been finally decided by any court?
decided by the trial court.
Then appeal is pending.
Appeal is pending.
So it has not attained finality.
No.
So res judicata does not come in. Then
Whether it ought to have been filed an application under the section 10
Then.
application.
withdraw this, move an application under section 10.
No.
Mr. A.R. Swam, the learned counsel appearing on behalf of the petitioner, submits that he would not like to press the instant application, taking into account the provision of section 10 of the Code of Civil Procedure. Accordingly, the instant application stands on withdrawal. He, however, submits that the withdrawal of the instant application should not preclude the petitioner to file an application under section 10 before of the Code of Civil Procedure 1908, seeking stay of the suit pending disposal of the appeal. Pending before.
District Judge.
Huh?
District Judge Siva.
District Judge Siva.
Appeal number?
Title Appeal 2 of 2021.
Title Appeal 2/2021
One.
in before the court of the District Judge, learned District Judge Sibsagar. This court observed that the withdrawal of the instant application shall not prejudice the rights of the petitioner with the defendant in the suit to file appropriate application. It is further observed that if such an application is filed, the learned court below shall duly consider the same in accordance. This court further vacates the order dated 31/3/2023 and taking into account that the parties are duly represented, the parties are directed to appear before the trial court on 25/2024. Yes, who died?
My lord, respondent number 9 died, ma'am. We have come to
What
know
is
by
the case you have filed?
My lord,
What is the case you have filed?
my lord, the list of witnesses are submitted. Instead of Jugen Bora, Jugen Pekya was written. That is the only thing. One, there was a draft writer, my lord. So while submitting the list of witnesses,
Hmm.
we had by mistake mentioned Jugen Saikia instead of Jugen Bora.
Hmm.
So the difference of Bora and Saikia is the basic crux of the matter.
Where is that order?
My lord, order is at page number. So my lord, we had filed actually 3 applications, my lord. All the 3 were rejected. Impugn order is, my lord, at page 89, 94 and 102.
You want to examine whom?
Jugen Bora,
Not Soikia.
not say.
Who is the scribe?
Jugen Bora.
Your Honor, they have like 3 times they have applied in the trial court and got rejected. They failed to establish the relationship as Jogan Bora and Jogan Saikia are the same person.
He is your witness.
Well,
You can very well bring him. Why do you need the list of witness?
that is why we press before the court. Court
It's
said
a
no.
simple question.
Absolutely, my lord.
Then what is wrong with the
Ah.
court? Order 16, Rule 183.
My lord, absolutely.
None.
Absolutely. Absolutely.
My goodness.
Your Lordship, my only submission is they have failed to establish the relationship.
Huh?
They have failed to establish that Jogan Bora and Jogan Saikia is one and same person.
Forget about that. It is his witness. He is going to bring him. You are going to bring him.
My lord.
Well, see order
Trial court has
16, Rule 183.
rejected their
What?
trial court had rejected their application for the 3rd time in a row.
Reject whatever may be rejected. They can very well do so under Order 16, Rule 183. Then isn't that the provision? What is wrong with the trial court? Subject to the provisions of A1 of Rule 1, any party to the suit may, without applying for summons under Rule 1, bring any witness to give evidence or to produce documents. So you are going to bring Jugen Saikia
Yes.
or Bora?
Bora.
You want to bring it? We'll say that these orders shall not preclude you to bring him as a witness. But when,
Your Lordship, my
what?
my submission kindly may record.
For what?
They have failed to establish the relationship.
Eh?
They have failed to establish the relationship kindly record.
Relationship of whom?
That Jogan Bora and Jogan Saikia is one and same person.
He's not saying that he is one and the same person. Are you saying that?
No, my lord, that is not required, my lord. What has happened while typing, my lord, that was a bona fide mistake. We had mentioned Jugen Saikia, it was accused, but I think Jugen Bora. So as an independent witness, we are bringing Jugen Bora under order 16-3.
So he's bringing under Order 16, 1A.
One.
Kindly my objection may be recorded. Your Lordship.
Okay. This is an application under Article 227 of the Constitution challenging the order dated 15/12/2022, whereby the petition filed by the petitioner, who is the plaintiff in the suit, for issuing summons to one Jugen Bora was rejected. Mr. A.K. Sahewala, the learned counsel appearing on behalf of the petitioner, who is the plaintiff in the suit, submits that irrespective of the summons to be issued by the court, in view of the provisions of Order 16, Rule 1A, the petitioner, oblique the plaintiff, would be can bring any witness without applying for summons to give evidence or to produce documents. Mr. So appearing on behalf of the respondents submits that the trial court on the earlier occasions have rejected the applications inasmuch as the plaintiff had sought for issuance of summons to one Jugen Soikia. The learned counsel for the respondent submitted that the plaintiff has to prove that Jugen Soikia and the Jugen Bora are one and the same person. This court have heard the learned counsel for the parties and have given a due consideration to the matter. This court have also perused the provisions of Order 16, Rule 1A of the Code of Civil Procedure 1908, which permits any party to the suit to bring any witness to give evidence or to produce documents without applying for summons under Rule 1. Also, taking into account that the specific submission of Mr. A.K. Sahewala that he is going to bring the said Jugen Bora as his witness without seeking the assistance of the court. This court finds no reason to debar the plaintiff to bring the said Sri Jugen Bora as the plaintiff witness in terms with Order 16, Rule 1A of the court. Accordingly, this court, without interfering with the order dated 15/12/2022 passed by the learned trial court, permits the plaintiff to adduce the evidence of Sri Jugen Bora in terms with Order 16, Rule 1A of the court. It is clarified that the said permission so granted shall not in any manner be construed as granting the permission to the plaintiff to seek the assistance of the court for obtaining summons to the said Sri Jugen Bora to adduce evidence. This court further takes note of that by an order dated 12/5/2023, the further proceedings of title suit number 10/2013 was stayed by this court. The said order stands vacated and the parties are directed to appear before the learned trial court, that is the court of the civil judge Golaghat, on 25/2024. On which date the plaintiff, oblique the petitioner, shall file the evidence on affidavit of Sri Jugen Bora.
Applicable.
Hmm.
As per I ordered the one to directed the petitioner to file a affidavit setting the said lordship at for 20 Accordingly, the petitioner filed affidavit setting the asset on the 10th for 2020.
Then
Then lordship made from the kindly visit on the on Friday lordship because the leading council out.
you have filed the affidavit.
Yes, lordship. Asset is setting that
Where is the affidavit? This is for reducing some amount, na?
yes, lordship.
How much it was given by the trial court?
34 then.
13 lakhs.
Huh?
13,
Directed to pay 30,000 per month.
30,000 per month.
Per month.
Okay.
For
You
48
do one thing, you file a reply to this.
Just I have this question.
You file a reply. Mr. So and so appearing on behalf of the
I am on behalf of KM Hassan Malik.
government. You will put your name on. So and so appearing on behalf of the respondent submits that he requires 2 weeks time for filing an affidavit. In reply to the additional affidavit filed by the petitioner on 10th of April 2000, 10th or 18th April 2024. To list the matter again on 17th of May 2024. In the meantime, the affidavit be filed by the petitioner. So the interim order passed earlier shall continue till then.
KM Hassan appearing matter. I am not the counsel, but that is medical emergency matter out of the. And this has been taken back. Dusty could not be taken.
Why?
It is medical emergency matter.
Okay. The materials on record show that the service is not complete. List the matter again on 10th of June 2024. Interim order passed earlier shall continue till then. 48.
We have taken step lordship, lordship also we have third lordship, but they have refused to accept affidavit file. For office to lordship, the registered or
None has appeared.
submitted the stay order for the
Then?
With their knowledge, but that for such accepted. Order 21 to 97 petition was accepted for completed, but no stay was granted.
Ms. R. Chaudhary, the learned counsel appearing on behalf of the petitioner, submitted that an affidavit in respect of dusty service have been duly filed. is the signature of whom?
Gampura.
Why you have given it to the Gambura?
I engaged counsel with representing the petitioner. It would approach the other engaged counsel.
No, it's okay. Refuse to receive
Refuse to receive.
RTI of Sibaran Nessa. Who is he?
She is the petitioner.
Refuse to receive.
Gampura himself approached the respondent.
Huh?
Gampura himself approached the respondent. They refused to.
You have filed an appeal.
Order 21 to 97.
Then why did you file an order 21 rule 29 also?
But along with that petition, order 21 to 29 was also filed. That was rejected. Thereafter, but my order 21 to 97 petition was accepted. And next date was fixed for written application by the decree holder. And by that time, Lordship, I have filed another application under section 151 to stay the further execution proceeding. That was also rejected. No stay was.
We have given some stay, na?
Yes.
Okay. Have illegal. This court fixes this matter again on 10th of May 2024. To stop. Interim order passed earlier shall continue till then. It is made clear. No, the 10th of May, no.
Registered date of 10th of 20.
17th of May 2020. Interim order passed earlier shall continue.
Okay.
Order. LCR received no. LCR not received, LCR received, but LCR not received by why the the office note dated 9/4/2023. 23 what? Such a long old order. 24. 9/4/2024 shows that the LCR of title appeal number 15/2055 have not yet been received. The registry shall take appropriate steps so that the LCR be requisitioned at the earliest. Immediately upon receipt of the LCR, the matter be listed for hearing, taking into account that this appeal is of the year 2006.
But this case is this appeal is ready for hearing. It may be listed for hearing.
LCR has not come. Hmm.
No, actually, the case was dismissed for default, dismissed for non-prosecution matter. And they restored it, my lord, without informing me, my lord.
Anyway, good, you are appearing. Respond number 5 had died. Respond number 5 had died. 5 died. Who is respond number 5? Lukta Begum. You are appearing to whom?
All the response, man.
Lukta Begum is dead.
The file is with my junior, my lord.
Huh? How are they connected? The record, the office note dated 9/4/2024 reveals that the respondent number 5 had expired. It also reveals that the LCR of title suit number 170 of 1989 have not yet been received. The registry shall do the needful as regards the LCR of title suit number 170 of 1989. Mr. Coenso appears on behalf of the appellant.
Yes.
And Mr. Coenso appears on behalf of the respondents. List the matter for it immediately after receipt of the LCR of TS number 170 of 1989.
So in this case, what happened? We were for the respondent, madam. The sole respondent died.
Hmm.
Then he was substituted, madam. There was the application for substitution as well as for madam. There were three miscellaneous applications, madam. Then one was for substitution 1541/2012. Another for condemnation delay of 170 days. There is 1542 of 2012, and there is another miscellaneous application number 1443/2012.
We dismiss it.
Yes.
We dismiss this application because in spite of the court serving the notice,
Yes.
they have not appeared.
Yes.
The record reveals, the office note dated 10/4/2024 reveals that the appellants were duly communicated on 7/6/2013.
13.
Thereupon, none has appeared on behalf of the appellant. It seems the appellant have lost interest in the instant proceeding, for which the instant appeal stands dismissed for non-prosecution. Mr. R.P. Sharma, the Learned Senior Counsel, assisted by so-and-so, appears on behalf of
Anasi Bora.
the main case. LCR. Yes.
I am for the respondent.
Hmm.
I am for the respondent. But the appellant yet not take steps upon the respondent number 8, despite the court order. Well, kindly see the order dated 25/1/2021, 14/6/2020. 25/1/21 is Lojima order.
None has appeared on behalf of the appellant on call. Mr.
Dikedas.
Dikedas appears on behalf of the respondent. Full stop. For the ends of justice, the matter stands adjourned to be listed again on 29th of April 2024. It is made clear that if the appellant is not represented on the next occasion, the instant appeal shall be dismissed for non-prosecution. Yes.
Lordship, here, two appellants, two of the appellants, and one defendant, one respondent had expired. And one of the appellant, of course, does not require a substitution because she has already been represented by her children. The other one requires, and the defendant also requires. So we have filed the substitution. Of appellant number 4 and respondent number 3.
How much delay? No delay.
No delay from knowledge.
No delay.
6 years, madam.
Huh?
6 years.
6 years.
Died in 2016, according to them.
Appellant number?
Appellant number 4, my lord. According to them, my lord, she died in 2016. Date has not been given, my lord. Paragraph 6, my lord.
Respondent number 3, when did the respondent number 3 die?
In the year 2019, my lord.
And you filed this application when?
February.
This is written. This is in February.
Huh?
Of February of this.
How is it possible? Without setting aside the abatement and condonation.
Abatement is there, but then of course perhaps the limitation will also be needed.
Then how do you take care of that?
Lordship, so far as appellant number 4 is concerned, we'll file a limitation. But so far as the respondent is concerned, we have come to know from them. We did not know that they died in 90s.
That is your ground.
So-
You have the CPC with you.
Sorry.
You don't appear without the CPC. You have CPC. You have a CPC. Fantastic. The learned counsels appearing on behalf of both the parties are not aware of the provisions of law under which the applications have been filed. They have submitted that they will go through the provisions and then address this court. It's a matter after 2 years?
No, Lordship. Let it be after 1 week, we'll file a limited.
Absolutely no. It's a matter after the June, July week. In the meantime, you go to the CPC, buy a CPC. You may require 2 months for buying a CPC. Both of you. This is a matter after 6 weeks.
It is your lordship. On the last occasion, it could call for the office note from the registry. Office note dated 19/4/2024. This shows that the steps has not been served. It has returned back as there was insufficient address.
Yes, let's see what does the office note say.
19/4/2024.
They sent only in 12/4/2024.
Yes, 12/4.
Appellant is in Guwahati, they are not in a position to serve it.
The address is shown as insufficient.
Huh.
That's why it was returned.
Obviously, resident of Zoo Road, Tiniali, PS Gitanagar, Guwahati, so and so, too big an area. Unless he is world famous. Or Zoo Road famous. Joydev Police. You are there in Mr. B.D. Dekar chamber? I'm fixing this matter again after 2 weeks. You find out what is the address of this person concerned. He was your client earlier. You left him. And now you have put the baby on us.
We have to the retirement of the also, Lordship, but no contact has been established from them.
Then how do we do with this appeal? You have done that, then you have forgotten now. What do I do with this? He's not interested, he's interested, nothing is there. So you have put the address as Joydev Polita and Zoo Road, Tiniali, Gitanagar 781024. Unless he's world famous. Is he so famous? Then what type of address you have put? Give us a proper address. You can't just shy away with this. Taking into account the office note dated 19/4/2024, this court directs Mr. A. Dekar to apprise this court as to what is the address of the appellant, taking into account that said that he's taking into account that he was representing the his office represented the appellant earlier. List the matter again on 6th of May 2024. The registry shall show the name of Mr. Edeka. Else I'll put you out there and do the matter and dispose of. Find him out.
Maybe. Not as per official dated 23/2014, 2024, madam. I have taken steps for starting to notice upon the number 4 by registered post. My learned son is appearing for number 1 and 3, madam.
Who is number 4?
4 is my Sobir
West Bengal.
West Bengal.
How do you serve him?
I registered post, madam.
Take correct steps. You have not taken steps by usual process.
No, madam.
Why? You don't want.
But,
The Learned Counsel for the appellant seeks for a week's time for taking steps by usual process upon the respondent number 4. List the matter after completion of service upon the respondent number 4.
the respondent number 2 is concerned. Respondent number 2 is concerned, madam. It duly starts.
Okay.
Apply.
Yes.
Service is complete, man. That service is complete, man.
Oh, fantastic.
LCR has the-
Mr. Roy is appearing for all?
No, no. I am appearing for only respondent number 2 and 3.
You are appearing for respondent number 2.
Respondent number 1.
You are appearing for 1, 2. Who is appearing for 3?
I am Lord.
Okay. Service being complete and records having been received. List the matter for hearing in its usual court.
I'll be open.
Yes.
In this case, respondent number 1 died, madam.
Who?
Respondent number 1.
Then?
My lord, so I have filed 3 applications. My lord, there is delay of 601 days in filing the substitution. There is delay of 601 days in filing the substitution application. Lordship may take up.
Then
IA 120, my lord.
you filed.
Yes, my lord. 3 applications are there. IA 120 is for delay, my lord. I have explained the delay in paragraph 3, 4, and 5, my lord.
Who died?
Respondent number 1.
How many respondents were there?
3.
What is the delay?
601 days.
Why?
Well, what happened in they come to know in the respondent number 1 died on 17th of February 2018. The appellant come to know in the month of December 2018. Thereafter, they have informed about the earlier counsel, but they have not taken the steps. So in the year 2019, when set up the case, then this application is filed.
You are paying for?
For respondent number 1A and 1B, opposite parties, Lord.
You want to be party?
Yes, Lordship, we have filed our objection in this
Why?
matter, Lordship, they have stated that the deceased respondent number 1 had died in the month of February 2018, and they came to know in the month of December 2018. But from the record, it clears that the parties are from the same locality. So it is difficult to understand that why they took almost 1 year to come to know that the respondent number 1 had died. And secondly, they put blame on the earlier counsel, and there was no such complaint on the part of the applicants against that he did not inform them about the requirement of filing the substitution petition.
Does the appeal abate? Who is the respondent number 1?
Sogra
Hmm?
Sogra Khan.
No, who is the respondent number 2?
Muhammad Asma Khatun. All are sisters.
Why the suit was filed?
The suit was filed for declaration of right title excess matter. Suit was dismissed against that it was deferred. Appellate court set title judge of the trial court. It took the severance of it.
You are the defendant. You are the appellant. You are the appellant now. But madam, who is appealing for 2 and 3? You are not the plaintiff. If it is abated against the respondent number 1, would the entire appeal abate? They were the plaintiffs. If they were the plaintiffs, then obviously it will be a joint decree. Decree for what? Right title and interest. So it will, once the decree against the respond number one becomes a change finality, it will apply for others. Rejudicator will apply. So your negligence of 601 days would be fatal for the entire appeal.
I have stated, my lord, I have stated the reasons for not.
The reasons are not convincing. Huh?
There's no negligence from the party.
Negligence, full-fledged negligence. What have you done against the earlier council? What steps you have taken? You can't say that, okay, one fine morning, oh, I didn't like the face of that council. I've changed it. That is what is your explanation. Matter never came up. Why did the earlier, the appellants out here chose the you? There must be some good reasons for that. What you have stated. Earlier we were not happy with him, so we changed it. Understood? Yes, there must have been something which went wrong during the proceedings. You may have reasons. So if we set aside, we don't condone the 601 days. Then, and looking into the fact that the client, your client has the habit of keeping on talking to the client, lawyer. I don't understand why the application was not filed. When were you engaged?
2019. November 2019.
Then, if you were engaged in November 2019, what stopped you?
But then I have filed in the month of January.
No, for you it's okay. What was the reason for? In November 2019, you were engaged. Then also you filed it on 10th of January. Then how do you explain that?
My lord, I have explained in paragraph 4, my lord. But then, my lord, during that, in the month of December, there is a curfew imposed in the and Difficult district to there is problem with regard to the transition. That's why they are not able to communicate. In paragraph 4, I have
And where do you stay? What steps have you taken against the earlier council? Who was the earlier council? The suit was decreed. You were a plaintiff. You were a plaintiff. Your suit was based on right title and interest. Your claim is on adverse possession.
Suit was dismissed. Suit dismissed. Against that appeal was referred, appealed for reversal.
Show me your written statement. Are the defendant number 2 and 3 represented?
There are so many councils, lordship, and that we have to take instruction regarding that. I'm not sure who is representing them. I'm appearing on behalf of Mr. Asif.
51 is the
Is your plea of adverse position? Huh?
first person as well as they have denied that the okay.
Record is only question of law is whether the finding of the learned area with below with regard to plea of adverse position is perverse to the materials on record.
That is the docket.
There's no substantial question of law. There's not a single pleading out there that you are the owner, that you are holding. Madam, we do until we condone the delay and then dismiss the appeal.
Whatever your lordship may deem fit.
Huh?
Whatever your lordship may deem fit.
I think better off.
To take up some other day.
Why? No, we do one thing. Other day, yes. I condone the delay today. Make them a party today and dismiss the appeal tomorrow. No case. Well, unnecessary doing that is an unnecessary problem. Hello, we'll have it on Thursday. We'll dismiss the appeal on that day. We'll make that and then you're ready for hearing. Now, this court have perused the application seeking substitution of the legal act of the respondent number 1 along with the application for condonation of delay and for setting aside the abatement. The grounds and reasons stated therein are that the earlier counsel who was handling the matter was duly informed about the death of the defendant number 1, and due details were also given for filing the appropriate applications for substitution of the legal heirs. However, the earlier set of counsel did not do the needful, for which the applicant filed the application, changed the counsel in the month of November 2019. It further appears from the materials on record that on account of various agitations, there was, during the month of November, late part of November and early part of December, that almost till the late part of December 2019, the applications could not be filed. It was only on 10th of January 2020 the applications were filed. This court is of the opinion that the grounds assigned therein are sufficient grounds for condoning the delay of 601 days. Accordingly, the delay stands condoned. The grounds and reasons next. The grounds and reasons set out in the application for setting aside the abatement have also been duly considered, and in the opinion of the court, the same merits in view of the reasons assigned. Accordingly, the abatement insofar as the respondent number 1 is set aside. This court further, taking into account that the respondent number, that the opposite party number 1A and 1B are the legal representatives of the respondent number 1, substitutes them as the respondent number 1A and 1B to the accompanying appeal. The registry, accordingly, the 3 applications stands allowed. The counsel appearing on behalf of the appellant is directed to file the amended memo of parties by tomorrow before the registry, so that the necessary corrections may be made by the registry to the cause title and also update the same in the CIS. Accordingly, the 3 applications stands disposed of. Main appeal. This court have also perused the materials on record as well as also heard the learned counsel appearing on behalf of the parties. List the matter again on 25/4/2024 at the top of the list.
Deeply.
Dismiss it on the Yes, any urgent matters? Oh my goodness, many. Urgent matters, so many councils waiting.
But next item,
Yes, what is that?
10 years has already been passed for passing of the appellate order. And after 5 years, they have filed second appeal.
So today, Lordship, regarding the service, Lordship, the service is the complete to the Lordship. At the last person of the remaining Lordship and the regarding that Lordship, I took the industry service Lordship, and that is Lordship I have and also filed an appeal Lordship. Lordship,
24 Nigi?
23, I have
23.
So you have any objection Lordship? They can file in objection in my IA Lordship in the condition of delay Lordship.
For what? How much delay?
Delay is Lordship, yes, 1434 days.
Huh?
1434 days.
Why 1434 days? So less? Oh, this in the meantime, the COVID. No, COVID has nothing to do.
No, before COVID.
Then why you are saying 5 years?
Yeah, about 5 years. 1430
Until 2020, 2020, I am on the issue of service.
So service is complete.
One person is remaining Lordship. That the Lodgema court referred this matter to this court Lordship. Lodgema or last order of the Lodgema court may be
The
seen, Lordship.
deponent went to the house of the respondent number 86,
Yes, Lord.
which two witnesses so and requested her to take this copy of the aforesaid petition, but she refused.
Yes, Lordship.
Only as 86.
Yes, only 86.
You have filed an affidavit of service.
Yes, Lord. Yes.
This court have duly taken note of the affidavit of service so filed by the appellant. And taking into account the contents thereof, this court deems service upon the respondent number 8, Roman 6 to be complete. List the matter again on 26/4/2026. On that 1434.
Yes, Lordship. That order.
Okay. Anything urgent? No, na? Any interim orders to be extended? Nothing.
Item number 36, my lord.
Hmm.
The interim was vacated on the last date. I
Which
mean,
one?
it was not extended the last date because the petitioners had also not appeared. We have put a respondents.
Which item?
Item number 36.
36.
Yes. So we will be filing a reply, and that's all. It's a very small prayer that we'll be filing reply, and the interim
Okay.
not be continued.
So it was not extended.
No, it was not. We are greatly thankful for that. Thank you very much because we have put a respondents. Yeah.
Okay.
After 1 week, it may be listed after 1 week as we.
The council appearing on behalf of the respondent number 1 and 2, 6 for an accommodation of 4 weeks.
1
week for filing reply. Why do you need to file a reply?
I mean, we have just filed an affidavit, but we have not obtained all the documents from Sibsagar yet. So, because we have put a respondent.
Okay, 6 for 3 weeks' time. List the matter again on 13th of May 2020.
May I please, sir? My lord, item 27, my lord, interim may be continued.
Yes, what is this?
My lord, in IA number 3676, 2022, my lord.
27, na?
Yes, my lord.
LCR received.
Yes,
Yes,
sir.
my lord.
Respondent, I am appearing for all the respondent file.
Okay, then we do one thing. RSA. This court duly takes note of that the service is complete and the LCR has been received. Accordingly, the appeal be listed for hearing in its usual course.
No, my lord, maybe after 2 months. My lord.
Why?
Because my lord,
The parties, however, at liberty to file appropriate applications seeking early hearing.
Alright.
IA की कौन देखो हाँ IA कौन एक IA C 3676/2020. Heard Mr. N. Hawk.
M. Hussain, my lord.
M. Hussain, the learned counsel appearing on behalf of the applicant, and Mr.
Choudhury, my lord, A. Choudhury.
A. Chaudhary appearing on behalf of the
Correspondent, my lord.
of opposite parties. So, taking into account that the appeal has been already admitted by formulating substantial questions of law, and the LCR has been also received, this court is of the opinion that the interim order which was passed on 14/12/2022 is required to be made absolute till the disposal of the appeal. Accordingly, the execution of the impugned judgment and decree dated 31/8/2022 passed in title appeal number 1 of the 2022 shall remain state till the disposal of the appeal. I stand disposed.
Alright, most of it.
Caveat discharge.
Most of it.
Anything more?
Item 33, here we have filed a fresh interlocutory application for stay of the execution. Earlier there was an interlocutory application filed by 33.
Oh, somebody mentioned it. I have told you something. Oh, yes, yes. I have fixed it on 26/4 because they have filed some IA for early hearing.
Yes. We have also filed a fresh interlocutory application.
That has come today.
No.
That is that old lady.
Yes.
Okay, I remember that. Caveat.
Okay.
I fixed it on 26/4.
Mark.